Hello, everyone. I am Mel Barrett, and this is Something's Off, a true crime podcast where we ask ourselves what the actual F on a daily basis. And right now, I am doing this series called Retrials with Mel, and we are covering the Georgia v. Edric Faust case. We went through, let's see, what did we do yesterday? We did sort of a recap of pre-trial stuff, and then we moved into the opening statements. And today we're going to finish up with witness testimony from day one and move into day two. And we're going to do that after a very, very quick break. Hi, everybody. Welcome back. Whew. There's a lot going on in the world right now, and I miss my Rebecca because there was a hearing today. Briefly, I'm going to tell you about this. There was a hearing today between Turtle Boy, Aiden Carney, and Meredith O'Neill. And it sounded like it got a little heated, not between necessarily the two parties, but apparently one of the lawyers, I think it was Meredith's lawyer. Oh, by the way, here's my shirt. Whack job. Um, there was some sort of altercation, possibly assault that happened. I would encourage you all to go check out Jess Machado's tweets. She did a stream about what happened in the court today. But bottom line is they are continuing this case, this hearing until Monday, which I don't think that Aiden's very happy about. But we'll know a little bit more about how Aiden's feeling because he's going to be on our regular Something's Off stream tomorrow night at 7 p.m. So I hope you'll join us. What else can I tell you housekeeping wise? Well, the DNA in the Sandra Birchmore case came through, and it looks like Farwell's DNA was on the ligature. I think we talked about that yesterday. There were also some IA videos that were released in the Karen Reed cases, one with Fanning being interviewed about Michael Proctor's grand jury testimony, which I found really interesting. We'll probably talk about that a little bit tomorrow. What else can I tell you? There's so much going on in the world right now. But I'm glad that we are here and we're going to be focusing on this case. While you're here, go ahead and like the video and subscribe and share and comment and do all the things that you can do to help us with the algorithm. Yesterday, we went well over 5,000 subscribers, and that is thanks to y'all. So I appreciate you. And if you like the work we do, send us a tip, send us a super chat. The tip, you can tip through Venmo or Cash App, and the Venmo QR code is on the screen. And at the bottom of the screen, it'll tell you about all the other stuff. So, yesterday was a lot. Today is probably also going to be a lot. But we're here for it. And we're here to understand this case and to understand the justice system and humanity a little bit better. And we got all that in this case. So, yes, next witness, wild day in the courts today. Hey, TC Nerd. Hey, I Live for Now. Just a Girl from the Six. Francine, Pamabo, Kendra, Danielle. Hi, Mel. So happy to catch the live. I know we're covering Faust, but do you have any intel on Aiden's court date? I'm on pins and needles. Yeah, it sounds like it's being, they're going to continue the court date on Monday at 2 p.m. I have a different chair, so I'm going to probably be swiveling a lot. I'm going to try to not do that, but that's what I do when I'm in a swivel chair. So happy hump day. Let's see. Yeah, right now the person who was in the courtroom and who did sort of like a play-by-play of the day was Jess Machado. So go to her Twitter and you can see the thread that she did about the case today. Hopefully, we'll be able to talk about it a little bit, at least what happened today, um, on our live with Aiden tomorrow at 7 p.m. So, oh yeah, that was the other thing. Thanks for reminding me. Just a girl from the six. Sounds like Chief Gray may be out in North Andover. So if you followed the Kelsey Fitzsimmons case, you will know that Chief Gray made some weird decisions with his department. That's to say the least. He also was sued by, and if you remember, if you followed the Kelsey Fitzsimmons case with me, you'll remember that we played a 911 call that was between Justin Alien and let me adjust this, and the North Andover Police Department. In one of those calls, he was advised by a Katie Gerke, who works for North Andover PD, about being able to go into Kelsey's house or not. And that same Katie Gerke also sued specifically Chief Gray for workplace harassment and sexual discrimination, gender discrimination. So it's really interesting. They had a vote of no confidence in him, and he is out, as far as I understand it. Yeah, Boston 10 reported no confidence in Police Chief Gray. It's good news, I think. Keep him accountable. Um, I Live for Now says, thank you, Mel, for your comment on FB defending us regarding the Faust case. Yeah, it was an interesting comment. Here, let me pull it up. See if I can find it here. By a person named Dylan Wilbanks, who I'm not familiar with, but I think he is a local lawyer in the Atlanta area, maybe. Um, and I'll just read you his comment and then I'll tell you what I said. This is on our private Facebook group, which is Something's Off with Mel Barrett and Rebecca Lavoie discussion group. Dylan said, some perspective from a local. It's Tara, not Tara, which I think I've been saying Tara. I might have gone back and forth in the beginning, but then I realized like it's Tara, and that's what I've been saying. Ahmad Cruz did not strike anyone as a genius. Oh, really? No one thinks he's a slick Atlanta lawyer. There are some, he's just not one. Athens is not a backwater. The elected DA has spent plenty of time doing defense work and recently ran and won as an independent. The ADA presenting most of the case is known to be easy to work with and is also well regarded. Judge Lott was a public defender before taking the bench. The Athens Clark County jury pool is one of the most defense favorable you can get. Changing venues from there would have been strategically unwise, even if it qualified for a change under the law, which probably wouldn't given its age. Your chat is likely wrong about the racial makeup of the jury. There was a pretty in depth local podcast, Classic City Crime, that covered the case extensively. Melton was interviewed on it. I would say it started out agnostic on him. The main podcast was 6 years ago, but they released an episode apparently with juror interviews recently. So, it's not really an incendiary comment, but it was kind of condescending and mansplainy and snarky. So I responded, I appreciate you sharing the local perspective. It's always helpful to have an intimate lens on the background of the people in the room, like Judge Lott or the ADA. I also appreciate the correct pronunciation of Tara's name. I say Tara, so it's good to know I'm doing it right, though it may have a slight New England accent occasionally. Tara. I do want to be firm about something here. As a white woman, I have to acknowledge my own privilege and the privilege a lot of us share in how we view the quote unquote system. We often want to believe that a resume, years as a public defender, or well regarded reputation guarantees a level playing field, but acumen and experience don't automatically erase bias. In my opinion, based on everything I've seen in the pretrial filings and the first 4 days of the trial, it feels like the DA's office and the local government have put their finger on the scale. And it looks to me like the GBI had blinders on from the jump. And there is a palpable sense that the jury felt an immense pressure from elected officials and a grieving family to finally put someone away for Tara's murder. We cannot ignore the reality that being a black man in a Georgia courtroom does not come with a strong history of fairness or justice. Statistically, the deck is stacked differently depending on who you are, regardless of how defense favorable a jury pool is reputed to be. I also want to stand up for my audience here. Most of the people watching Retrial with Mel have lived and breathed this case. They've watched the entire previous trial and have formed very strong, informed opinions. They aren't just reacting, they are analyzing. That being said, I'm committed to go through this entire process and I'm looking at every ruling and every piece of testimony. In my opinion changes If my opinion changes by the end of this, I will be the first to tell you. You know that. But right now, from where I'm sitting, the optics of justice in this courtroom look very different than the biographies of the people running it. So I think that is what I Live for Now was referencing. It's okay to have discourse. It's okay to have differing opinions about this kind of stuff. But to say for a white man, who Dylan Wilbanks appears to be from his profile picture, to say that that this case was tried fairly and that it was judged fairly, um, really just sort of discounts the racial bias that I think most of us are seeing in this case. So I wanted to bring that up. Okay, Judge Canoni. I don't even know what that's in reference to, but Ani Bev was brought up, so I'll allow it. I gave up my very steamy audiobook to be here. Well, um, I don't know what to say to that. I'm happy you're here. I might have to maybe I'll have to put on my ASMR voice or something to um to keep you engaged. Um you were quite spicy yesterday. This is her sister comment has me giggling. Yeah, that was a fun we had a fun stream, Rebecca and I, that it was 2 nights ago. I think it was not yesterday but the day before. And for some reason, I guess everyone really enjoyed it cuz it's gotten a lot of hits. Um So, yeah, I don't know. We were talking about the Kelsey Fitzsimmons, the Justin Alien filing in the Kelsey Fitzsimmons family court saga. So, I don't, we just had a good time. Hopefully, it'll be like that tomorrow night too. I've Rebecca and I have had Aiden on once before, but it was behind a paywall. It was on our readathon, which was on Rebecca's Patreon. So this will be the first time that we are going live with Aiden, and I expect it to also be a little spicy. So we'll see. Yeah, I'm not sure if Chief Gray is out either. I hope he is out. I would say that this is probably going to push him out. Dot. But he definitely got no confidence by the union, which is a good thing. To the comment you're reading, why wouldn't any local defense attorneys take Edric Faust? Please stop. The podcast is ridiculous, one sided, and biased. I haven't listened to it, so I can't really comment on that. A lot of people in the comments said they had listened to it. I don't know. I'm not really sure who Dylan is. I think he just joined the Facebook and may have followed along on Twitter or something like that. So he must have seen some of this coverage and didn't like some of the things that I and you guys were saying. So he thought he needed to put out a public statement in defense of the entire area and the legal system there. So, uh, pretty sure that's Chris's bestie running that podcast, meaning Chris Melton's bestie. Wow. Yeah, this is one of the big things, Kathy, that I was like, yeah, when I heard this, I was like, what is going on in North Andover? Chief Gray took Noonan's firearm after the incident and gave Noonan his firearm. That's a big no no. Yes, it is. Yes, it is. Who knows what happened with those two firearms? Melanie Little had a few of her watchers in the courtroom and could see the jury makeup. Uh, I don't know how to pronounce your name. Zakowski, I think. Yeah, I mean, from what I've heard, and I've heard this a lot from everybody, that it sounds like there were two jurors of color on the jury and everyone else was white. I feel like I've heard one Hispanic person, one black person, and I have heard from several people that the black person was the one who said they were tired and done with this case and they wanted to go home. But I don't know if that's true or not, and not that it really matters. Um, Mr. Cruz is a saint. He has patience, respect, and knowledge. I see no evidence to convict Mr. Faust, said Francine. Um, but he's basically saying we don't know what we're talking about, and that's BS. Next witness said, "Yeah, I agree. I know. I'm sorry. I'm spinning in my chair. I know. It's so bad. I'm like a kid. My microphone's weird too. Let's see. I will take it as a compliment here for the tea. Next witness says, "Trust us, Mel. He's besties with Chris and extremely biased." Well, I haven't listened to the podcast. I don't really have plans to listen to the podcast. So, I'm just going off of what's happening in the trial. I'm making up my mind based on what's happening in the trial, based on some of the interviews I've seen with Ahmad Cruz. So that's where I'm coming from. Let's see. They posted the jury list before the trial, which is crazy to me. I had heard that. That is really crazy to me too. They should not be doing that. Yeah. Okay. So yesterday we finished up with opening statements. We're now moving into testimony. I have so the way that I'm going to do this today is we're going to watch just about everything that happens, but I'm going to skip through bits and pieces. I've pulled out time code for all of the witnesses, all of the arguments that happen outside of the jury and outside of the witness. Actually, one of the things that is so crazy to me about this trial is that a sidebar will happen and then they'll release the jury, they'll tell the jury to leave, but the witness sits on the stand and then they work out what they're talking about, that what they had been talking about at sidebar in front of the witness. And it's usually about their testimony or evidence, and I'm just like, why are we doing this? That just kind of gives the witness an idea of how to testify, doesn't it? Did anybody else see that and think it was weird? I have not listened to Liz's testimony yet, guys. I know you want me. I'm trying to take this as it comes. I'm trying to take this like day by day. I've personally listened to the testimony and the trial for about 3 days, but I haven't like sat down and focused on it and taken notes and done time code and stuff like that. So that's what we're doing here. So you'll have my sort of in the moment response. Um, Kendra said, "Yep," and then the witness knows exactly how the state wants them to answer. Yeah, it's crazy to me. That yeah, the as what they did in front of the witnesses kind of blew my mind. And to me, that feels like it might be something that the appeal can be based on, because a witness shouldn't be sitting there listening to the why, like the arguments for objection or the arguments for a motion when it has, can you guys hear that big truck? When it has anything to do with the testimony that they're giving on the stand for the state, because we're still in the case in chief for the state right now. So the judge is rude. Okay. Let's get into it. So the first witness we're going to hear from is former firefighter, Athens Clarke County Fire Department, David Freeman. Oh my God, when defense had to show his cards while Chris was on the stand. Ooh, I don't know about that yet. We'll get to it. Okay. So we're going to go through this. I am going to put it on a faster speed so we can get through it. So we're going to be at we're going to be at 175. Let me know if that's too fast for you guys. I usually listen at 2, so I'm bringing it down a little bit, but let me get this up on the screen. Day 2. No, this is day 1. Just kidding. Yeah. Okay.
Is the defense ready?
Yes, ma'am.
All right, thank you. Statement called first witness.
David Freeman?
Could you get David Freeman, please?
David Freeman. And also the judge's mic and that the squeaking, it drives me nuts. I hate that sound so much. And I heard somebody say earlier that I think the DA is the one who is.
So I'm going to ask you to raise your right hand, please. Do you swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? You can have a seat.
Why are the lawyers swearing these people in? I don't understand that.
Sir, I'm going to ask you to state your name and spell it for our court reporter, please.
David, D-A-V-I-D, Freeman, F-R-E-E-M-A-N.
Sir, I'm going to ask you, back in 2001, how were you employed?
I was a firefighter at Athens, Clark County.
Okay. Can you tell the jury, please, just a little bit about your firefighting career with Athens Clark County Fire Department?
I was generally assigned firefighting or driving the truck. I did both. When I say firefighting, I mean actually pulling the hose off and, fighting fire.
How long did you do that, sir?
26 years.
Was there a primary station that you worked out of in those 26 years?
I worked in all of them at one time or another. I worked at all. We had 6, then we had 7, then we had, I think we got 8 now, but I worked at all of them at one time or another.
Do you recall where you were working in January of 2001? Which station?
Station 5.
Which one is that?
Whit Davis Road.
Mr. Freeman, do you recall being dispatched with other Athens Clark County police or Athens Clark County firefighters to a call at 160 Fawn Drive?
Yes, sir, I do.
Is that address in Athens Clark County?
Yes, sir, it is.
Do you recall approximately what time of day that call came out?
Generally, we clean up the station in the morning, check the truck, do household stuff. And it was before lunch. I can't tell you exactly what time.
Okay. Mr. Freeman, if you could please describe what you observed as you approached 160 Fawn Drive.
The call came in, I believe, as a structure fire. Me and another firefighter were on the back of the truck, which means we actually have the nozzle. We pull up to the front of the house, or front of the apartment, and you could see the left side of the apartment. It had broken through. You could see flames. So as a firefighter, you're taught to go in the front and push the fire outside. So I had the nozzle. We went to the front door. I was putting my mask on, and I reached up and tried the door, and it was locked. And I believe the lieutenant on the truck is who actually kicked the door in. When he kicked the door in, I mean, it was almost like a training fire. You could see smoke had come down about head high, and we're taught to crawl. But that day, the smoke wasn't all the way down, so I could see a glow in the right side of the back of the room. Which
I'm going to stop you right there. So just to clarify a little bit, did you go in the front door of the house?
Yes, sir, we did.
And as you enter the front door, where in the house are you situated? If that makes sense.
When I go in the front door,
Yes, sir. I just kind of generally
the best I can remember, because when we pulled up in the truck, you could see the fire in the left back of the house, and you could see the flames shooting through. So I had in my mind that when we went in, I was going to go to the left. Well, when we kicked the door in, you could see in the right back of the room, you could see red glowing.
And what did you do when you saw that red glowing?
We actually went to that area, which turned out to be the kitchen, which turned out to be all the eyes on the stove were on.
You say eyes, what exactly do you mean?
The old coral type electric stoves.
Okay.
They were all on and glowing red.
Did you notice anything about the knobs to the stove?
Did not have knobs on the stove.
Where were the knobs?
I can't. They were either on the counter. I don't think they were on the stove, but I think they were on the counter. They were taken off.
Okay. Did you yourself turn the stove off?
I believe I did. Yes, sir. I had to. I don't know if they were in the right place, but I put the knobs back on there and turned the stove off, and then.
Okay. What'd you do after you turned the stove off?
Lieutenant was over. He was walking across the room back towards what now we know is the bedroom, but he told me, said, open the back door to let some of the smoke out. So I had on my gloves. So I reached up to open the door, and it was locked. So it was pretty warm in there. So I took my glove off and I opened the door. I believe it had a deadbolt and then a regular lock. So I opened the door, and at that point, the lieutenant said, come over here. So I had the nozzle.
Okay. You had the nozzle. He said, come over here. Where did you go?
I went from the stove kitchen area across what was the living room to what we now know was her bedroom, and that door was closed also.
What happened next?
We tried to open the door, and it was locked. So the other firefighter that was with me, I think Doug actually kicked that door too. And, I said, when he kicks the door, it's going to roll out, because I knew it was what we call rolling. It was
when you say it's going to roll out, what are your
the fire? The fire's going to roll out, because when we rolled up, we could see it burning through the roof. So I knew it was pretty intense. So when he kicked the door, I opened the nozzle, what we call Z'd it. I Z'd it down, knocked the fire down, and then they said,
Z'd it.
I hit it one more time just to kind of cool it down, and I had put my hand. We were just sitting there kind of watching it, make sure it didn't flare back up or flame up or whatever. And I always kept a big rubber band on my fire helmet. And I had a light stuck, up there in it, and I had my hand down on the floor, just kind of sitting there watching to see if it. I mean, smoke had banked all the way down in this room, and then I turned the light. When I turned my head, I looked down and I saw her at the foot of the bed. And
can you describe in detail what you saw?
There was a nude lady laying there.
A nude lady. Jesus.
Almost looked like. I mean, you could tell she'd been in extreme heat, and she was also like a mummy, like she didn't look real. Her hair looked like her hair was intact, but it was.
So I know you said that she's on floor, do you recall how she was positioned?
She was positioned with her feet towards the door. Best I remember, we go in the door, the bed was to the left, and then she was at the foot of the bed, and then looked like the flames or the fire was on the bed.
Do you recall how her body was oriented up, down, otherwise?
She was face up.
Upon discovering the body, what did you do next, sir?
Like I said, we were trained just to make sure it doesn't flame back up or anything. And so Steve and I were still in the room, on the floor. And the lieutenant, which was Doug, he was standing at the door behind us. And he said, y'all don't touch anything, just make sure it doesn't flame back up and back out. So that's basically what we did. We got it cooled down, and then we backed out.
And after backing out, did you, and when you say Doug, is that Doug Whitehead?
Yes, sir. He was a lieutenant on the seat that day. He was a supervisor, you might say.
And you mentioned Steve. Is that Steve?
Steve, yes, sir. He was a firefighter also. He and I were on the back of the truck. We had a driver of the truck. We had Doug was a supervisor, lieutenant, and then we had two firefighters. Steve, Sheldon, and myself were on the back of the truck.
And after y'all backed out of the room, did you turn the scene over to the police?
Yeah, we called, I guess they called the chief and the assistant chief. Anyway, the shift commander was already there. So I guess they notified police, and, it just kind of become chaos at that as everybody started showing up. And they wouldn't let us go anywhere. We had to stay there.
At any point, did you take notice of a screen to the back window in the house?
Yes, sir. When we got it cooled down, and I guess I was in shock. I just went to the back door because I had two small daughters. I went to the back door kind of trying to collect my thoughts and whatever. And there was a window to the left side of the door, and the screen, I can't say if it was laying in the yard or if it was leaned up against the house, but the screen had been tampered with. You could tell where like if you take a screwdriver and try to pop it out, you can tell where it had been bent. It had been tampered with.
But not enough.
Just a moment, Your Honor. Mr. Freeman, those are all the questions I have for you.
Good.
Cross-examination, Mr. Cruz.
Yes, ma'am. May I move the podium, please?
I think Cruz does a good job here, especially with the window screen. He showed the pictures to the jury in his opening, and there's no way someone broke in through that screen, got out, put the screen back,
Good
and then it
afternoon,
wasn't more
Firefighter
mangled.
Freeman. How are you today?
I'm great. How are you?
I'm doing well. Is it okay if I ask you a couple of questions?
Yes, sir.
You mentioned the back door to the home. I just want to make sure I'm clear on this point. When you opened the door, did you have to unlock the deadbolt and the bottom portion of the door?
With no glove on. Yes, sir.
With no
Would it be
glove
fair
on.
to say that based on your examination of the home, the doors were locked and there was no evidence of forced entry?
That would be correct. No forced entry to the doors. And like I said, the screen on the window looked like it had been tampered with, but but no, there was no forced entry to the doors. No, sir.
Sure. Do you recall completing a interview with firefighter report from January 19th, 2001?
The report that I had to write.
Yes, sir.
Yes, sir.
Would you agree, and if you don't know, actually, would you agree that you were asked the question 29 in that report, were the doors locked when the first units arrived? Do you remember that question?
I really don't even remember the report you were referring to. I had to write a handwritten statement of what happened that day. Usually the supervisors make out the fire report.
Yes, sir. I'm going to show you what I am marking as Defense Exhibit 1. Yes, sir. Is it okay if I approach you?
Yes. Okay. Yes, sir. Were the doors locked when the first unit arrived? Yes, they were. Was any force of entry? I put no.
Yes, sir. You mentioned the window. I know that it's been 25 years since you responded to the scene. Do you recall what that window looked like at the time that you saw it?
It was a could have been like a white, seemed like it was a white aluminum frame or vinyl window. It was two panes, top and bottom. Like I said, it was to the left of the back door.
Would you recognize that window if you saw it again?
Possibly.
I'd like to show you what's being marked as Defense Exhibit 2 and Defense Exhibit 3. Thank you for your patience.
Yes, sir.
Hey, Jen.
And to make sure I have this correct, this window was to the, if I'm facing the back door, it would be to the right. Is that correct?
Left.
If I'm facing, oh,
If you're coming in the front door,
okay, it's to the left. Is that
the
right?
window is to the window is to the left of the door that's on the right.
Excellent. I'm going to show you what's been marked as defense exhibit 2 and 3. Your Honor, may I approach?
All right, so we're going to show the screen from the
Yes, sir.
window.
Do you recognize the image?
Yes, sir.
Okay. Is that a fair and accurate depiction of the window as you viewed it on the day you responded to 160 Fawn Drive?
Is this the way I found it? Is that what you're asking? I mean, it's just,
Correct. Well, do you recognize?
I can't honestly say. I remember, as you can look at this and tell, it looks like it's been tampered with or whatever, but I can't honestly say that the screen was outside, was not on the window. I mean, over 26 years, I had numerous calls, and I can't 100% say that screen was off. I'm pretty sure it was, but I can't sit here and say, I know it was tampered with because I remember seeing this.
Yes, sir. Did you make any notations in the report I provided you? I believe that was defense exhibit 1, if I'm not mistaken, about the window screen.
No, sir.
Would you have any reason to say that those images have been altered in any way?
No, sir.
I'd like to show you defense exhibit 4. May I approach, Your Honor?
So I believe
Yes,
there
sir.
was testimony that, and it might have been from one of the
Do you recognize the
roommates
defense exhibit
that
4?
I saw.
Yes, sir.
Okay, you recognize defense exhibit 4 as the screen at 160 Fawn Drive, or the screen in the window at 160 Fawn Drive. Is that correct?
Yes, sir.
Okay, is that a
And
fair
the
and accurate?
roommates
Defense
had-
exhibit 2 through 4. Are those fair and accurate descriptions of?
Yes, that's
Oh.
looking at this.
Instead of talking over everything and everything's moving fast. From what I recall, just from hearing the testimony from one of the roommates, they had actually made a complaint to the landlord or whoever owned the apartment that the screen was kind of messed up and that they had issues with that back window. So it when I saw pictures of the screen, like I've had those metal framed, like aluminum framed window screens before in apartments or houses that I've lived in. And the only way to sometimes get them off, because they have these little like bolts basically that go in that fit into place, is you take a screwdriver and you have to pop it out, and it does bend the aluminum. But this guy is the first firefighter on the scene. He makes a handwritten report, and in it he says all the doors were locked, no forced entry. And I'm going to say this again. I said it yesterday. If a stranger came up to this heavily crowded, you guys remember the pictures of this neighborhood. There are houses all over the place, right? And people all over the place. A stranger walks up to this house just randomly. They all look the same. A stranger walks up to this house, doesn't know anyone in the house, doesn't know who's going to be in the house, and doesn't decide to go into one of the doors, but decides to pop an aluminum screen off a window. Hope that the window's open, I guess. Who knows? And if the window's not open, then what? Hope that the window is open, and then goes through the window, randomly sexually assaults the woman who is inside this house, not knowing if anyone else is home, not knowing if anyone's going to come home in the middle of this attack, randomly, brutally beats, stabs, and grapes this woman, and then sets the house on fire. And while the house is starting to be on fire, wipes down all the surfaces of fingerprints and cleans up after everything, and then goes back out the window and either leaves the screen on the ground or puts it back in the window. We're not really sure from this guy's testimony. And the window frame is just a little bit, oh my God, I just had a yawn that just took me over. Sorry. The window frame, or the screen frame, just has a little bend in it from where you popped it off with a screwdriver. Does that mean plausible? Does that sound plausible to any of you all? That's a lot of risk for this really heinous, brutal act that had no motive. I mean, what is the jury thinking? I can't imagine sitting on this jury and thinking, oh yeah, that all makes sense. Yeah, totally. That all makes sense. Absolutely. Yeah.
This is where I got the idea that it had been tampered with.
Yes, sir. Your Honor, I would move to admit defense exhibit 2 through 4 into evidence.
Any objection? They are admitted.
May I approach, Your Honor?
Yes, sir.
May I publish anything?
May.
I want to thank you so much for your heroism. Those are my questions.
Any redirect by the state? May this witness be excused? Any objection?
No, ma'am.
You are free to go, sir. You may call your next
Okay.
witness.
Doug Whitehead.
Could you get Doug Whitehead, please?
So we're gonna move forward a little bit here to Doug Whitehead. I think Doug is, yeah. Okay. And this is going to be the last witness for day 1, and then we'll move into day 2.
I do.
Can you state your name, please, and spell it for our court reporter?
Doug Whitehead, D-O-U-G,
Doug
W-H-I-T-E-H-E-A-D.
Whitehead.
Good afternoon, Mr. Whitehead. If you could please, sir, tell the jury what it is that you did for a living.
I was a firefighter, sergeant in Athens Clarke County Fire Department.
How long did you work for the Athens Clarke County?
Almost 35 years.
When did you start and when did you stop?
Started January 1st, 1977, and stopped sometime in January of 2011.
Over the course of your career with Athens Clarke County Fire Department, did you work in a number of different stations around town?
Oh, yes.
Specifically in January of 2001, do you recall where you were stationed back then?
Station 5 on Whit Davis Road.
Whit Davis.
Mr. Whitehead, on January the 19th of 2001, do you remember being dispatched to a house fire at 160 Fawn Drive?
Yes, I do.
Is that in Athens Clarke County?
It is.
Just real quick, to get from Station 5 to Fawn Drive, how would you get there?
Well, we turn left out of the fire station, go to the intersection at Lexington Road, turn left. Believe it's the next road to the right is Cooper Road, and Fawn Drive would be off of that.
So when you turn onto Lexington from Whit Davis, are you turning left?
Turn left at the red light towards Athens.
Do you remember about what time of day that call came out?
11-ish, I believe.
Describe, if you can, sir, what you personally observed when you arrived at 160 Fawn Drive.
Smoke coming from the rear of the apartment.
And so what did you do next?
Told the guys.
Let me ask the chat a question. There's only about 55 or 54 of you in here. Of the 54 of you in here, who watched the trial before? And I'm asking the question because this witness is basically almost a carbon copy of the last guy. So if you all have seen this already, I feel like we can sort of skip through it. Everything that is established in the first witness's testimony is also established in this, including on the cross. So let me know. Because I don't want you guys to get bored. These are just like kind of set up witnesses. They're not really doing much to tell us about the case other than to say, like, I'm not even sure why the state brought these guys in, because what they're saying is the whole place was locked from the inside and there was no evidence of forced entry. And that should already hurt their case, but for some reason it didn't. Yeah, let's skip through this guy. So I can tell you he pretty much says the exact same things as Freeman said. And so, but he was like a supervising lieutenant. He confirms they had to kick in the doors. He tells the same story that Freeman told about where like seeing the body for the first time, that the fire burned through the sheetrock and insulation and the roof, leaving a hole where daylight was visible. The fire in the room was primarily overhead. Let's see. One of the biggest things that this guy said was that he testified that the source of the fire was the knitted sort of Afghan blanket. The killer had placed the blanket on the stove, which had all 4 eyes on high, allowed it to ignite, carried it to the bedroom, and threw it under the bed. He noted that the remnants of the melted burn Afghan were left on the stove and had dripped on the floor leading to the bedroom. And he said that to his best recollection, the back window screen was taken out and propped against the house. So that's really the only difference in his testimony. And then Cruz sort of hammered it home again. All the doors were locked and that there was zero evidence of forced entry. And that sort of solidifies the defense's theory that Tara either let the killer in or the killer had a key. Neither of those two things are Edric Faust, just for the record. Okay, let's move into day 2. And I think we have some procedural stuff at the beginning of day 2. So let me check that out. Okay. And we update 2. Okay. Lost. Let me see my notes here. Okay, so this pretrial is going to be the state is requesting to introduce a redacted version of the autopsy report. The original report lists 2 names as suspects who were not Edric Faust or Chris Melton. I find that interesting. The state argued that leaving those names in would confuse or mislead the jury since the trial had zeroed in entirely on Faust and Melton. And then Cruz basically says, I'm going to reserve. I don't object right now, but if, I will reserve my objection for the time if I feel like I need to object. And the judge gets a little bit snarky with him. So let me play that bit for you because she's this judge. It's like every chance she gets, she's, pulling some shit, basically. Just saying some shit. I don't understand her attitude, honestly.
In so doing, I have what is very clearly not a real knife. So I just didn't.
Okay, so he's talking about having a fake knife. And then
The state's preference to tender the redacted version. That
All right. Mr. Cruz, any comment on the state's proposal?
In regards to the fake knife, no. I think the most appropriate thing is wait till the attempt's introduced. By having objections, I'll make the objection at the time, Your Honor.
All right, thank you. All right, I'll allow you to introduce the redacted portion since there's been no objection. All right, anything else from the state before we bring the jury in?
No, I reserve my objection. I just didn't have any objection. Once they attempt to introduce, if I have an objection, I'll make the objection at the time.
You're certainly entitled to do that, but for now, in terms of allowing the redacted version, and you haven't made an objection, so I'm going to allow it in. If you want to object when it comes in, you certainly have the right to do that. All right, thank you. Anything from the defense before we bring the jury
so
in?
cunty.
All right, thank you. Bring the jury.
She's just so cunty. I don't really use that word for a lot of people, but her immediate response to anything that Ahmad Cruz says is attitude and condescending, and I feel like she's always trying to like catch him. You know what I mean? Hello, Allie. Happy to have you here, love.
All right, thank you. Everyone may be seated.
We're
All
on
right, ladies and gentlemen,
day
good morning. Thank you
2.
for being here on time. As instructed, we're ready to begin. Again, with regard to the state of Georgia versus Edric Lamont Faust, SU24 CR0547. Is the state ready to proceed?
Your Honor.
Is the defense ready to
And
proceed?
first,
All right, thank you. Ms. Golden, you may call your next witness.
Dr. Andrew Falzon.
Could you get Andrew Falzon, please?
this is the medical examiner. Let me see if I have this going too fast. Yeah, it's at 2. There we go.
Sir, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? You can have a seat. Sir, if you could state and spell your name for the record, please.
Sure. My name is Andrew. Last name is Falzon. Falzon.
Yes, please hit the like button.
Sir, where are you currently
everybody.
employed?
I'm currently employed as a consultant pathologist with Mater Dei Hospital in Malta, Europe.
And what are your role, or what do you do as a consultant forensic pathologist there?
I oversee a pathology lab, one of the satellite labs on a separate island, and I also provide forensic services to the hospital.
Can you tell the jury a little bit about your prior employment before
gonna skip
working
through
at
some of
the
this.
hospital in Malta?
So I started
He's a medical examiner. He's obviously qualified.
flying exams. I am board certified in anatomic, clinical, and forensic pathology.
Have you spoken
1440.
at conferences related to the area of forensic pathology
I've presented at mainly.
from law enforcement, I guess?
Yes, I do.
Okay. At the time, do you recall, or would you have noted receiving any historical or case information related to the request for the autopsy?
Typically we would receive that. I haven't seen any copies of those recently, so I don't recall exactly.
Can you tell us briefly what an autopsy consists of?
An autopsy is a post-mortem examination, typically
We know.
performed to establish the cause and manner of death. We would start by reviewing the history surrounding the case. Then we'd move on to the examination of the body. In certain cases, we would do x-rays prior to actually starting the examination. Then you describe the clothing, remove the clothing, collect any trace evidence if indicated, and then you start the external examination, the examination of the body from head to toe, front and back. Once that is documented and you look for any injuries, document those, take the necessary photographs. Then you move on to an internal examination whereby we do an incision across the chest and abdomen, remove the organs of the chest and the abdomen. We'll make an incision across the top of the scalp, remove the skull cap, examine the brain, and finally we examine the neck organs. During the course of the autopsy, we'll also collect specimens for toxicology and DNA as indicated.
Do you also take photographs while the autopsy is being conducted?
Correct.
And is it common practice to reduce the findings of your autopsy in the form of a written report?
Yes.
Of course it is. I lived in Texas myself for 6 years. I graduated high school there, and I had horrific experiences in Texas, and I'm glad I don't live there anymore.
Okay.
I'm going to hand you Mark States Exhibit 1. Do you recognize that, sir?
Yes, I do.
What is States Exhibit 1?
It is a copy of the autopsy report drafted and signed by myself.
Is that the autopsy related to the case involving Tara Baker?
Correct.
I move to tender States 1 at this time, Your Honor.
Any objection, Mr. Cruz? It is admitted.
Dr. Falzon, I'm going to go through your report kind of sequentially as it's outlined in States Exhibit 1. Let's talk a little bit about the receipt of the body. I think I kind of just touched on this earlier, but if you could speak to what your report reflects as to how the body was received.
Correct. The body bag was, there were tags affixed to the body bag zipper that had the case information relevant to this case.
Can you speak generally to, you mentioned an external examination. We're going to try and take it in order. What was the first thing that you did with Ms. Baker as it relates to that external examination?
Photographs would have been taken, and then overall assessment of the body, the charring, the degree of rigor mortis, and the stiffening of the muscles that happened post-mortem, any lividity, the setting of blood in the dependent areas, general observations.
Let's talk a little bit about the injuries that you noted to Ms. Baker's body, starting with those on the head and neck, sir. Can you describe those in general?
The injuries on the head and neck were mainly in the form of blunt force injuries. When we describe injuries, there's three main categories: blunt force injuries that are caused by a blunt instrument, whether that be a fist, a piece of wood, a hammer. Those are all blunt force injuries. There's sharp force injuries that are caused by objects with a cutting edge. Could be a knife, could be a shard of glass. And then there's gunshot wounds. In the case of Ms. Baker, she had multiple blunt force injuries, mainly in the form of bruises around the eyes, the right and left sides of the head, and on the neck. She also had, on the neck, she also had a stab wound on the right lower front of the neck, and she had a ligature mark that surrounded the neck.
Okay. Specifically as it relates to the stab wound, can you describe in a little bit more detail what you observed?
The stab wound, like I said, was on the right lower front. When I describe a stab wound, typically I will imagine the face of a clock overlying the wound. And in this case, the wound was oriented between the 10 o'clock and the 4 o'clock on the lower front of the neck.
Okay. You also mentioned a ligature mark encircling Ms. Baker's neck. Can you speak a little bit more to that, please?
Yes. The ligature mark completely encircled the neck. It had one mark on the back of the neck and two marks on the front, which indicated that the ligature had been wrapped around the neck, crossed over in the front, and the ligature held on the sides.
Did you note any other injuries to Ms. Baker's neck?
She had some blunt force injuries to the neck. I'm not sure if there's something specific, if I may look at the report. She had contusions, bruises below on the left ear, below the left ear, and behind the left ear.
Moving, and we'll back that momentarily, Dr. Falzon. Did your external examination of Ms. Baker also include injuries to her torso?
It did, yes.
And again, I'm going to ask you to just briefly summarize the extent of those injuries that you observed.
The injuries to the torso were mainly in the genital and anal area.
Can you go into a little bit more detail about those injuries, sir?
Again, they were in the form of blunt force injuries, bruising on the right side of her vulva down to the posterior aspect of the vulva, and she also had a bruise that completely encircled the anal region.
Mm.
And lastly, Dr. Falzon, did you note any injuries to Ms. Baker's extremities?
Yes, it did.
And what were those?
Those were mainly in the form of sharp force injuries, injuries caused by a cutting instrument, and they were limited to the back of her hand, which could be classified as defensive type injuries, the injuries that a person would sustain trying to ward off an attack.
Did part of your internal examination of Ms. Baker include examination of the organs of the neck?
Yes, I did.
And particularly, what, if anything, did you observe in that part of the internal examination of Ms. Baker?
As part of the examination of the neck structures, we look at the bones and the cartilages that make up the neck. One of the bones that we have in the neck is called a hyoid bone. It's a C-shaped bone that sits above the larynx. With case of strangulation, we often see fractures in the hyoid bone. In the case of Ms. Baker, there were fractures on both the right and left sides of the hyoid bone.
And based on your training and experience, sir, what, if any, significance did you attribute to your observation as it related to Ms. Baker's broken hyoid bone?
That was part of the strangulation process.
That's awful.
Dr. Falzon, you mentioned that as part of the autopsy, you do take photographs.
Correct.
Going through the photographs to make sure they're okay. Am I down here?
The upper chest, including the lower extremities, and you can see the charring of the body in this photograph.
States Exhibit 4. What do we see here, sir?
This is a photograph of the face of Ms. Baker, showing a degree of charring and also the blunt force injuries that I alluded to prior, notably the bruising around the eyes.
I don't think we know what time the
Exhibit 5.
autopsy was, but it happened on
Is it just slightly
January
different angle,
20th,
of her face?
2001,
Correct. It's
the
a
day
slightly
after
closer up view
Tara
of
was
the
found by
face.
the firefighters.
Same question as it relates to States Exhibit 6.
Again, closer up view, focusing mainly on the right eye.
Awful.
States Exhibit 7.
This depicts the left side of the face, and there's again jarring, and you can see there's a braided laceration, kind of like a U-shaped, inverted U-shaped lesion on the left side of the chin.
States Exhibit 8.
Okay. This is a photograph
U-shaped.
depicting the left side of the face, neck, and the left shoulder, and you can see the ligature mark on the posterior aspect of the neck.
States Exhibit 9. Is that just kind of a closer up photograph of what you just described?
Correct, and you can see the single linear mark that extends over the posterior neck, and you can also see the bruising behind the left ear.
This is States Exhibit 10. What do we see here, Dr. Falzon?
It's a photograph of the neck aspect. You can see the ligature mark on the top, which is an electric cord, and you can see the plug aspect, the prongs on the left-hand side of the photograph.
And Dr. Falzon, I think you can actually, if it would be helpful, you can, the screen in front of you, you can touch and circle things. Just to clarify what you just described as it relates to the ligature. And I think Your Honor might have to, Mr. Dickey explained that there's a
Elmo.
Yes.
Turn the Elmo on.
Okay. So you made some drawings on.
The U-shaped, I need to erase that. Okay. But so I'm marking here the cord, and that's the prong aspect and the plug attached to the cord there.
In this photograph, is the stab wound that you previously described also identifiable in this photograph?
That would be...
Right. Thank you, sir. States Exhibit 11. What do we see here, sir?
Again, you see the cord here. Difficult to see because it's...
In the circle at the end, is that the
that's the end of the
plug?
plug, yeah.
This is hard to follow because we can't see the pictures ourselves.
Exhibit
Not that I
12.
really want to, but
What are we seeing here, Dr. Falzon?
It's the front of the neck. Again, there was extensive charring, and there was a lot of smeared dried blood on the skin. But you can see the stab wound. And the stab wound had what we refer to as the blunt edge and the sharp edge. When you have a knife, obviously you have a cutting edge of the knife and the back, the non-cutting part of the blade, and they both leave kind of distinct characteristics. But this would be the blunt end there at the back. So you see the blunt end on the, I guess, on the right-hand side of the body, with the sharp edge more directed towards the middle of the body.
We'll come back to that later, Dr. Falzon. I'm going to move on for now. This is States Exhibit 13.
overkill.
Is that just a slightly
Overkill,
different angle of the stab wound that you just described?
Correct.
States Exhibit 14, particularly on Ms. Baker's left shoulder. Did you reach any conclusions about that area where there's no charring sir, if that question makes sense?
Right. It looks like an area of what we call sparing. There's no soot and charring on that area, and most likely that was where the plug was resting, kind of like protecting the skin from the soot deposition.
State's Exhibit 15. That's just a slightly different picture of different angle of
Correct. Closer up view.
what we just described. Okay. Okay. These are where it gets even tougher. State's Exhibit 16, Dr. Falzon. What is this photograph?
That's a photograph depicting Ms. Baker's genital area.
Oh God.
You can see the bruising. The above, this would be kind of like an area of charring, heat damage. So this is not part of the injury she sustained while she was alive, but you can also see the bruising around the introitus, the entryway to the vagina.
And we're going to follow up on that with State's Exhibit 17. Again, I apologize. State's Exhibit 17, what is this a photograph of, Dr. Falzon?
This is a slightly different angle of the anal-vaginal area. You can see a bruising that completely surrounds the anus, which would be this area here. And then you see the bruising on the right-hand side and the posterior aspect of the introitus, the entrance into the vagina.
State's Exhibit 18, is that just a slightly different angle of the last photograph, sir?
Correct.
Almost done. State's Exhibit 19, shifting gears. What are we looking at here, sir?
This is a photograph of the back of Miss Baker's left hand.
State's Exhibit 20, is that just a slightly different viewpoint of that left hand?
Correct, and it's showing what we refer to as an incised wound. With sharp force injuries, you can have stab wounds where the knife is actually penetrates, the blade penetrates into the body, or you can have an incised wound where the cutting edge is dragged along the surface of the skin. This here is an incised wound that we see.
State's Exhibit 21, again, are we just kind of looking at that same left hand, sir?
Correct, and you can also see there's another incised wound, another cut in the web space between the fourth and fifth finger. So that would be that area there.
Defensive wounds.
And then finally, State's Exhibit 22, is that just a picture of the ligature that you previously described after it had been removed from Ms. Baker's body?
Correct.
Dr. Falzon, I want to first talk about the injuries that you described and the photos that we've seen in Ms. Baker's genital area. And you described those and we've seen the photographs. Based on your training and experience coupled with your observations of that area of Ms. Baker's body, what, if any, significance can you attribute to the causation of those injuries?
Those would be caused by sexual intercourse with force used.
As it relates, and then I realize I'm jumping around a little bit, as it relates to your observations with regards to the ligature and Ms. Baker's, the fact that her hyoid bone had been broken, and again, based on your training and experience, what, if any, significance do you attribute to the causation of those injuries?
So the injuries on the neck that we saw from the cord and the fractures of the hyoid bone would be the result of strangulation, ligature strangulation.
This is all overkill and it's very passionate.
Dr. Falzon, as it relates to your observations of the stab wound that you previously described on Ms. Baker's neck and the wounds, which I believe you previously referred to as defensive type wounds to her left hand, do you have, and again, based on your training and experience, do you have an opinion as to the mechanism by which those injuries may have occurred?
Those would be sharp force injuries inflicted by a knife. Just to expand on the stab wound, as we described the injury on the skin, but once the internal examination is performed, there was actually injury to the internal jugular vein on the right side, which is the main vein that drains blood from the right side of the brain, which would explain the amount of hemorrhage, the blood on Ms. Baker's skin. And that would have been caused by a knife.
Okay. And did you, were you able to form an opinion as to how that stab wound may have been inflicted?
I have the same.
Given the orientation, the location, and the orientation of the wound, as part of the assessment of the stab wound, I also tried to ascertain.
Yeah, as far as I understand it, Chris Melton's DNA was found on the ligature. And I mean, that's what Matthew Farwell's DNA was found on the ligature on Sandra Birchmore. And we're all pretty convinced he did it. So I don't understand. I'm going to say this again. I don't understand how a little bit of DNA in her mouth, as opposed to Chris Melton's DNA all over her body, as well as one of the murder weapons. I don't understand why the jury didn't see that Edric Faust is not the murderer in this situation. I'm wholly confused by that. And I think you all are as well. And I don't know if we'll ever have the answers to that question, but I feel like somebody needs to answer for it.
The direction in which the stab wound was penetrated into the body. So in case of the stab wound that we saw on Ms. Baker's right neck, the knife entered through the skin and it went from front to back, downwards and to the left. In my experience, that has often been due to somebody being stabbed with the perpetrator standing behind the victim and forcing the knife into the body cavity like that.
And again, referring to your observations as to the incised wounds on Ms. Baker's left hand, what, if anything, do those wounds tell you about what you just referenced?
Those would indicate that Ms. Baker would have been in the process of trying to protect herself from the stabbing while it was being performed.
Would it be helpful to the jury to kind of demonstrate what you just described, sir?
God.
Yes.
Well, Your Honor, is it okay if I ask Dr. Falzon to step down into the level?
Fine.
This is where the fake knife comes in. Oh, Emily, congratulations. I'm so glad that you have been approved to be
Ms. Baker. And so what you just described on the stand, sir, if you could kind of describe
to foster dogs. That's
So
amazing.
the entry wound would have been somewhere here.
Adopt, don't shop.
So with holding the knife like this, the blunt end would be at the 10 o'clock position and the short end would be at the 4 o'clock position.
And again, as it relates to the injuries to the hand, how would that, in your estimation, have occurred?
So if she was trying to hold on to that, would explain the cut on the space between the 4th and the 5th finger. Again,
Oh my God,
the
this
direction
guy's
would be,
so fucking
front to back,
awkward.
Downwards and to the left.
Thank you for your testimony. Dr. Falzon, based on everything that we've talked about, question, I'm going to back up just a little bit. Did your autopsy of Ms. Baker reveal anything as it related to her larynx?
She did, yes, it did examine the larynx, the voice box where the vocal cords sit, and she did have a slight amount of soot present below the vocal cords.
Did you also, as part of this autopsy, request or refer Ms. Baker's blood be tested for the presence of carboxyhemoglobin?
Yes, it did.
And are you familiar with the results of that report?
Yes, I am.
And what was that?
I believe it was between 6 and 14%. I may have to jog my memory. I gave you back the report, but
Now, let's talk a little bit about carboxyhemoglobin.
Okay.
What is that?
hemoglobin is a molecule that transports oxygen. It picks up oxygen in the lungs, takes it and deposits it in the periphery of the body, and then picks up carbon dioxide and releases that back in the lungs during respiration. Now,
Thanks,
when as part of the fire, carbon monoxide is formed. So carbon dioxide is carbon with 2 oxygens. Carbon monoxide is carbon with 1 oxygen. Carbon monoxide tends to attach somewhat more strongly to the hemoglobin molecule, and it actually prevents hemoglobin from transporting oxygen. So when somebody is exposed to a fire, we test the blood for carboxyhemoglobin, which is essentially hemoglobin attached to a carbon monoxide molecule.
And so based on your observations of soot being deposited below Ms. Baker's voice box and the results of the carboxyhemoglobin test that you just described and testified to, is that significant in any way to you, in your opinion, doctor?
The level of carboxyhemoglobin was not high enough to be considered a cause of death. Typically, we expect carboxyhemoglobin to be more than 50%. People who smoke tend to have elevated carboxyhemoglobin levels. But in the case of Ms. Baker, the presence of the soot below the vocal cords and the slightly elevated carboxyhemoglobin level would indicate that she was still alive when the fire was set.
Thank you, Dr. Falzon. So again, just to summarize everything that you've testified to thus far, were you able to form an opinion as to the cause of death of Ms. Baker?
Yes, it did.
What was that opinion?
Yeah, she
So
was
she
murdered.
died of a ligature strangulation and a stab wound of the neck. I also described the bruising on the head, the blunt force trauma of the head. As part of the internal examination, I did examine the brain, and there was some subarachnoid hemorrhage on the surface of the brain. So the other contributory factor would be blunt force trauma of the head.
Did you rule the manner of death, Ms. Baker's death, a homicide?
Yes, it did.
Overruled.
Dr. Falzon, you mentioned that part of a autopsy may include taking an X-ray or radiograph if there is evidence of a stab wound. Did I understand that correctly?
Correct.
Why do you do that?
When somebody is stabbed, the
Relevance. It's undisputed that Ms. Baker was stabbed.
All right, Mr. Bolden, do you care to respond to the objection?
Trying to allow Dr. Falzon to testify to everything that was done as part of Ms. Baker's autopsy.
I'm going to overrule the objection. You may continue.
That's for the same courtesy during our examination.
I'm sorry, Mr. Cruz. What do you mean by that?
We just ask for the same courtesy. That understands.
When there's an objection made, I will rule on it. Mr. Bolden, you may continue.
She's going to
Do you
chastise him
also
for that comment
obtain a
later.
sample of Ms. Baker's blood?
Yes, I do.
What is the purpose of that?
That would be performed to collect the specimens to submit for testing for toxicology.
And is a
Okay, let me pause really quickly because the conversation that you guys are having in chat is a good one and very interesting to me. And if anybody, I don't know how much you guys know about my background, but I've been talking on the phone with Pamela Smart and her family for over a decade at this point. So if you all want me to facilitate a video call with Edric or whatever we need to do, I'm happy to do that. I mean, I'd probably want to talk to his lawyers to make sure that's okay. But I think it's a great idea. And I think that for folks who are incarcerated and who have either been in for far too long or who are wrongfully convicted and are incarcerated, knowing that they have this kind of support on the outside is one of the, it's really hugely important to them. So anybody who wants to write to Edric or who wants to get on a video call should. I don't know if any of the rules in the specific prison that he's in require certain people to be sort of on his call list. I know that Pam is only allowed 15 people, I think, on her call list. And so if she wants to add somebody, she's got to take somebody off of her call list, which is hard to do. You pick 15 people that you want to communicate with on a regular basis. And so taking somebody off is difficult. But I think that, I think it would be good for him to hear, about the support he has. You guys can also donate. I had the Give, Send, Go up. Where did I put it? I think I put it in the episode description. But the link to his Give, Send, Go is there. I know they're trying to raise $150,000 for his appeal. And I think they've raised about 55 so far. So if you're able to do that, I would suggest doing it. It's really helpful. The only way people can get through these processes is to have strong attorneys. I think we've learned that after watching a lot of trials. If the lawyers aren't good, you're going to suffer, whether you're guilty or innocent. Yeah. Is there an appeal plan in place? I believe so, Jen. I mean, he has, I think that Ahmad Cruz is still on the case because when I went to the Give, Send, Go for Edric, all the proceeds are going to Ahmad Cruz's law firm. So it sounds like they're still heavily involved. There's so much to appeal in this case, and I'm hoping that the problem is that appeals are really difficult. They don't often go through. They don't often give you the result that you're looking for. And certain states are very strict with their appeals. And, if I'm looking at like Pam Smart, sorry, I'm yawning. I'm so tired today, guys. Sorry. If I'm looking at the Pam Smart case, she's, kind of exhausted most of her appeals. And oftentimes when she files a petition or she files an appeal in the state of New Hampshire, as an example, she filed an appeal back in 2018 or 19. And it wasn't an appeal, sorry, it was a petition for commutation. And it was a 700 plus page document. So imagine a file that's about this thick. That had, legal matters in it, but for the most part, it was people who had written in corrections officers and wardens saying, she doesn't deserve to be in prison anymore. And with that stack of paper sitting in front of them, a panel of judges looked at it for 3 minutes and said, yeah, no. So something that took her lawyers and her supporters and a bunch of other people years to put together, that is a novel of why this woman shouldn't be in prison, and this panel didn't even read it. they looked at it for about 3 minutes and said no. And so that's my fear in these kind of, states and cases, is that the prosecution is never going to admit they made a mistake in this case in particular. So I don't know. I don't know what to expect. I do think he has a good team. I think they probably have a good plan, but what they need is money. They need experts, and experts are expensive. So if if they need to hire experts for his appeal, some experts, you saw the Karen Reed case. Some of those experts charged them like over $200,000, and ARCA, charged the government a ton of money. So I think the things that we can do is donate to the Give Send Go, and write to Edric, write to Ahmad Cruz's office. You can probably email his office. More than likely, you can message Edric, because if he has access to video conferencing, then he probably also has access to electronic messaging like Pam does. It just makes me sad. Sorry, I'm just getting a little emotional about it. Yeah, I've been hearing a lot about Brian Steele being on this, and he's got a hearing coming up. I don't know the exact dates, but I believe it's in June. Yeah. I think especially now for him, now that the trial's over and the verdict is what it is what it is. I think it's really important for him to know that he has a lot of support still, and that everyone's still talking about this, because it's when a case goes away, it's when people stop talking about it, that is like really detrimental to the person who's sitting in prison. So yeah, I think they definitely need a DNA expert. Okay. Sorry, I just wanted to put that out there. I am happy to put that together if you all would be interested, and maybe I'll get in touch with Cruz and see what he thinks.
A blood spot filter card also submitted?
Yes.
And
All right. I'm going to sustain that objection, Mr. Bolden, if you'll rephrase.
I'll rephrase it, Your Honor. What other physical evidence is, obtained or submitted as part of an autopsy?
To establish a reference point for DNA testing, a blood spot filter card is prepared, whereby we take a filter paper card and we put drops of the victim's blood that is air dried and then submitted for analysis.
We're about to get into some big objections here.
Was a sexual assault kit obtained in this case?
Yes, it was.
Can you explain briefly what we mean by sexual assault kit?
A sexual assault kit has various components to it which help in collecting evidence in cases where sexual assault is suspected. It would have swabs to collect DNA. It would have slides whereby we smear the swabs and prepare smears to look at under a microscope. It would have nail clippers to clip nails and envelopes, put those nail clippings in. And it would also have envelopes for samples of head hair, pubic hair, and pubic hair combings.
And I apologize if you mentioned this already, but when you're talking about swabs, from where on Ms. Baker's body were those swabs obtained?
Swabs are taken from the mouth, oral swabs, from the vagina, and from the anus.
Great.
And again, I apologize if I just misheard. You mentioned smears as well. How are those smears created?
The smears are created from the swabs. So we put a Q-tip with cotton tipped end, and that would be inserted in the cavity, the oral cavity, the vagina, the anus. Once fluid is absorbed onto the cotton tip, while it is still wet, we would take the glass slide and smear the tip of the Q-tip on that slide to prepare the smear.
I think that, just to answer a couple of questions, I think that Edric is still, and correct me if I'm wrong if you all know better, but I think he is still in Clark County Jail until he's being transferred over to a state prison. So I don't know. I don't know if he's been transferred yet. He might already be in the prison, but I'm not sure. So basically what you have to do is you have to go through the, Georgia corrections, figure out where he is, figure out what his inmate number is, and then you'll be able to set up messaging for him.
Your Honor, we have a motion.
All right. Ladies and gentlemen, I'm going to ask that you go into the jury room. Don't discuss the case. This is a good time for a bathroom break. We will be with you shortly.
Yeah, I assume he's still in jail and maybe being transferred over at some point to the state prison. Wait, is Jimmy doing a show at the
Y'all may be seated.
Wilbur?
Thank you. Mr. Cruz, your motion, sir?
I want to do the simple thing first.
I'll
We have
have
an
to be
objection
at
to
that
the
if he
non-punitive
is.
care of a victim. Exhibit 31 is empty. So that's
Your
empty.
objection is to Exhibit 31.
Right, but I do
Okay.
have a motion.
Okay.
No, but I want to hear your objection, and then you can make your other motion. Go ahead.
I'm going to showing this to Dr. Falzon on this reference to the identified item.
Can't hear what he's saying.
Okay.
They had items. None of them. You have a motion.
All right, well, let me have Mr. Bolden respond to your objection on Exhibit 31. Go ahead, sir.
Your Honor, I'm sure Dr. Falzon, we can open it. I guess the objection is the fact that it's empty somehow that makes it indivisible. I don't know if that's the case. I don't know that I know how to respond to that particular objection.
I make it clear. It's confusing. The pubic hair, relevant for his testimony, an empty bag that just says pubic hair is irrelevant for this case. That's what we're objecting to. Now that we are objecting.
All right, Mr. Bolden, you care to respond to the objection about relevancy?
Again, I think the fact that Dr. Falzon testified that pubic hair is taken, why do we let him look at it? Because Mr. Cruz is searching that empty. I honestly had not opened the bag, so let's allow him to do it. We can do that momentarily. I'd like to hear the motion. Sure.
All right, that's fine. We'll hold off on Exhibit 31's objection. Go ahead, sir.
We're moving to suppress the oral swabs due to chain of custody. In this case, it has been stated that oral swabs, vaginal swabs, and anal swabs were taken. We have the chain of custody report. The chain of custody report says that only 2 oral swabs were taken. I assumed that was pretty much an error on the chain of on the custodian because Ms. Bigham, 2024, conducted a test on these swabs, and it was determined they went to a company in California to do this test. That's something we'll address across the nation instead of using a company here in Georgia. But that company came back and said, you know what? We did this presumptive test. These are actually vaginal swabs. However, now that I'm seeing the original packaging that Dr. Falzon put these items in, please correct me if I'm mistaken. A vaginal swab was taken. Alex, show the report, sticks exhibit 28. Sticks exhibit 29.
I don't know that I need to see the exhibits at this moment. I want to hear your objection about you're asking the court to suppress it.
I would ask the court to suppress the, I'm asking 2 things.
Okay.
I'm asking the court to suppress, I believe it's oral swab E. Let me confirm which swab it is, Your Honor. Where's it going?
Yes, Allie, that's a great idea. Allie says, I moved for a letter writing campaign from the Something's Off crew. Great idea. We can talk about it a little bit more when we have a break. I just want to get through.
Right, so one of these are labeled with item
Okay.
2I.
Yeah.
Of course, we can say item 2I.
Okay, so let me talk a little bit about what's happening here. There's a huge issue with a lot of the evidence, a lot of the forensic evidence in this case, physical evidence in this case. So Cruz is moving to suppress the oral swabs, which the state's 2024 testing categorized as actually vaginal swabs. So the original investigators or forensics, they labeled these swabs oral swabs. And then later on, after forensic testing was done at the California lab, they realized, or they categorized them as vaginal swabs. And so Cruz is moving to suppress these because there is pretty much a huge break in the chain of custody. And he's arguing that because Falzon testified, an unsupervised technician packaged and labeled the swabs, the state couldn't prove what was actually inside them. And we're going to hear what everyone else has to say about that.
So for purposes of the record, oral swabbing B is labeled as item 2I, as in blue. Oral swabbing A is labeled as item 2J.
The struggle is teal. That's how they do it here. They handle everything. I mean, I just want to keep in mind, you're not seeing this on the screen, but the witness is sitting there. The medical examiner, Dr. Falzon, he's sitting there and he's listening to all of this. And so is open court. The jury is gone, but it's like, how are we doing this in front of a witness? I don't understand. And you're going to see, as I started to see, as I watched a few days, the amount of times you remember from the Karen Reed trial how many sidebars there were. And we were all frustrated because we had no idea what they were saying at sidebar, right? We know now, which have been very interesting. Thank you to Corey Hopkins, Marbury versus Matt on Twitter. So what's happening right now is, in this case, basically every time there's an objection and somebody wants to make a motion or do something, the jury is sent out. They do all of this in open court in front of the witness, and then they bring the jury back in. There are times in the testimony that's going to be coming up, you're going to see the jury sent out of the courtroom like every 3 minutes. And then we talk about something, and then we bring them back in, and then a couple minutes go by and there's another objection, and then we send the jury out. If I were on the jury, I would be frustrated. So I understand the idea that there were some people on the jury who were like, I'm so over this. Like, I want to go home. I'm sick of this case. Like, I get that. Unfortunately, you are on a jury and it is your obligation and duty to give it your best, because this man who's sitting right here on the screen in the white shirt has now been convicted of, and he's got 2 life sentences and then an extra 45, which whatever that means. You only have 1 life, so I never get that. But so like it's frustrating, I know, and I would be really frustrated if I were in this courtroom and this jury, but this is how they do it. And it gets even more frustrating because it starts to happen a lot more.
As enjoyed. So, Your Honor, on November 4th, 2024, this wasn't discovered by November 4th, 2024, Pure Gold Forensics.
Okay, hang on just a minute, Mr. Cruz. Let me ask you this question. Are you making a motion to suppress?
I am. But this is based on knowledge I just learned just now going over these incidents. So this isn't a motion that was untimely because I knew about it 10 days before, and I just learned this.
All right, let me stop right there just for a moment. Is there any response to the motion to suppress as opposed to a motion to eliminate or an objection based on something else? Go ahead.
Yes, I would object to this being characterized as a motion to suppress. Mr. Cruz, we've had hearings going back months. We've discussed making any physical evidence available to him to inspect, and we would have done so at any time. He never asked. He asked in court, but never followed up with that. This evidence we would have gladly shared with Mr. Cruz at any point had he actually asked, but he did not. I don't think what he's asking for this morning, well, again, I don't know a motion to suppress at this point. I don't know what legal grounds he's asking.
Cruz is getting pissed.
Chain of custody. I think that argument is more of a weight versus admissibility issue. So it's very hard to respond when I don't understand exactly what is being asked in court.
All right, thank you. Mr. Cruz, let me ask you this question. With regard to this motion you're making now, is it, as you stated earlier, about the issue of the chain of custody?
Correct.
All right. I'm making a ruling right now that that is not a motion to suppress issue. You are entitled to cross-examine this witness or any witnesses with regard to the chain of custody, and I'm not going to allow.
Listen,
If you have an
listen,
objection to
Lisa
something else
Lott.
about the admission of this evidence, I'll hear it.
She's such an ass.
The phrase is irrelevant.
No, it is not, Mr. Cruz.
Well, the state, when chain of custody issue is raised, the state has the burden to show that that this evidence is the same evidence that was selected and that it wasn't tampered with. The issue we have is that both of these items from Dr. Falzon, both of these items were collected by him and labeled by him. There's going to be testimony in this trial 24 years later that, actually, one of these is a vaginal swab. Dr. Falzon, as you heard from his testimony, is very careful, he's very diligent. It sounds like Texas Congress does work the right way. So we're moving for the safety of chain of custody for these items. meet their burden to show chain of custody for these items and that they were not tampered with, or we ask them to exclude any mention that oral swabbing B is a vaginal swab, because from what I'm seeing for the first time today in court, it is not.
All right, Mr. Cruz, I'm going to overrule your objection, and I'm going to deny your motion, and I'm going to make the statement that the complaint that you're making in the form of an objection and the request to make a motion is certainly appropriately addressed by cross-examination. You have every right to cross-examine any witness with regard to chain of custody, with regard to the issues of tampering, anything that is relevant to the evidence that's being offered. You have every right to cross-examine with regard to those issues. And so that's the reason I'm denying your objection. And if there are any other objections to the admission of that evidence, I want to hear it now. I want to address one more thing before we bring the jury back. Any other objections to the admission of that? I mean, I haven't ruled that admissible yet. We haven't made there hasn't been a proffer, but if you have something that you'd like to object to now that you know about, so you can do that.
We will stand by our chain of custody motion.
All right, thank you. I do want to make a comment, Mr. Cruz, and this is really for all parties, but it's related to the comment that you made a little bit earlier. You did not make an objection, but you stated something to the effect of, we're asking the court to extend us the same courtesy. My comment to all parties, but particularly to you with regard to that comment, is this. That comment about the court's behavior is not appropriate in the manner in which you said it. The court makes rulings of law, not courtesies. The court extended, Mr. Cruz, you a courtesy this morning when you were 20 minutes late. I knew why you were late, and I extended you that courtesy. That's a courtesy. But in terms of this trial, and in terms of making comments in front of the jury, the only appropriate comments to be made are not comments. They are objections. They are proper examination questions, cross-examination questions, things of that nature. And the court will respond to proper objections. Any comment on the courtesies of the court or fairness or things of that nature that are not in the form of objections need to be made outside the presence of the jury. And that's my statement.
Yes,
thank you. Anything else before we bring the jury back in?
All right, if we can have just maybe a minute for us to take a restroom break.
All right, why don't we be off the record until 11:15? That's about 12 minutes.
What she's talking about. So yesterday in opening statements, if you were here or you've seen the trial, you remember that Lisa a whole lot held Ahmad Cruz in contempt and ordered him to show up in court first thing in the morning with $1,000 for the court. And so obviously court starts at 8 or 9. They have to be there at 8 or 9 or whenever. And banks don't generally open until 9. He had to go to the bank and get $1,000 in cash and bring it to the court. And that's why he was late. And she knows it. But to be like, you were late and I extended this courtesy to you. Fuck off. The semantics they play in this trial. It's probably a good thing that I'm not sitting in a courtroom, because I'd be calling people out probably, and that would be a problem. So it's good that I'm doing it here and not in a courtroom. Although I have been thinking about maybe going to law school, because I'm starting to see and I'm starting to understand that if you don't have good lawyers, you don't have a chance. If you can't afford good lawyers, you don't have a chance in this justice system. So I'm just, when I hear a judge say something like that, for instance, she allows the district attorney, who's the man who's standing up right there next to Ahmad Cruz, she allows the district attorney to tell her during an objection that Ahmad Cruz should be held in contempt. And then she goes ahead and she does that. But there's no chastising him for telling her how to do her job. She's only chastising Ahmad Cruz when he says, we would just like to have the same courtesy extended to us that you have extended to the prosecution. He's not being rude. He's not saying anything that the jury shouldn't hear. It's ludicrous. It's ludicrous. And every time that something like that happens, she takes it so personally that this building rage directed at Ahmad Cruz, you can just see it happening in her face. It's like her turtleneck gets bigger or something. So I just can't. I can't. Let's see. $1,000 cash. Eesh. Miss Holmes said, this trial was so brutal to watch the first time around, and no, this judge must have gone to the school of Canoni for how to be the best biased, corrupt judge ever. Yeah, Emily, I agree. I can't with this lady. I used to think judges were some of the most reasonable people, but I don't anymore. We have seen a couple of judges of late that have given me a little bit more hope in the system. The judge, Judge Karp, and the judge in Corey Richards' trial. Those two guys were very centered, very reasonable, very thoughtful, and were able to, even if at first blush they thought one way, they were able to take a step back, get outside of their ego, and go back and read case law and rule a different way. And I really appreciated that about them. Let's see. Never too late. I'm 54. I just turned 50 in February. I love my 50s. I'm so happy to be in my 50s. I would love to. I mean, and the only reason that I would become a lawyer is to become a criminal defense attorney, because I feel like there are so many people who need representation, good representation, and don't have it. But I don't know if I have time right now. So, okay, let's get back to this. All right, we're taking a pee break because the DA needs to take a whiz. So let's
We'll be in recess until then. Thank you.
Forward here a little bit. And I think what we come back with, we'll be on a cross when we come back here. Yep, boop, boop, boop. Okay.
Bruce? All right, thank you. You may bring the jury in. All right.
Bring the jury in.
We were talking about the collection of the sexual assault kit. Is that right?
Correct.
Okay.
Great.
I am going to, if I may approach the witness, Your Honor. I think, Dr. Falzon, this is State's Exhibits 23 through 30. Dr. Falzon, let's start with State's Exhibit 23.
Yes.
What is that, sir?
It's a clear plastic box with a label marked with the case information, and it's marked fingernails left hand.
And would that be the fingernail clippings that you took from Ms. Baker's body on January the 20th, 2001?
Correct.
Lieutenant State's 23, Your Honor.
Any objection?
No, ma'am.
It is admitted.
No, ma'am.
24, Doctor, what is that?
It's a clear plastic bag sealed with evidence tape. There's two clear plastic boxes, each one with a label with the case information. One is marked toenails right, and the other one toenails left.
Again, same questions before. Are those related to the autopsy that you've been describing this morning?
Correct.
How do you know that, sir?
Each one has a label on them with the decedent's name, Clark County, the age, race, and sex, and the unique case identifying number assigned to this case.
Any objection?
No, ma'am. I won't have any objections to any of those outside of the objection already put on the record.
All right, thank you. Number 24 is admitted, and you may proceed, Mr. Bolden.
State's 25, Dr. Falzon, what is that?
25, it's a white paper envelope sealed with evidence tape, and the label with the case information, and this one is marked oral swabbings B.
And
Oral.
again, same question. Is that related to the autopsy that you performed on Ms. Baker on January 20th, 2001?
It is.
Lieutenant State's 25, Your Honor.
And based on Mr. Cruz's assertion, is that right, sir, that there's no objection?
Outside of my prior objection.
Then it is admitted. Thank you. And
He's
that's
like,
26?
I already objected.
25.
You didn't let me
25.
object.
25. Thank you. Go ahead.
State's Exhibit 26, what is that, Doctor?
Same white envelope with evidence tape and the unique case identification information, and this one is marked oral swabbings A.
Move to Tender State's 20, now I've forgotten. 26, Your Honor.
26. Mr. Cruz, any objection, sir? All right, it is admitted.
State's Exhibit 27, Dr. Falzon, what is that?
White envelope, red evidence tape, label with the unique case information, and this one is marked rectal swabbings.
Move to Tender State's 27.
Mr. Cruz, any objection, sir?
Agreed, Emily.
admitted.
We need more stubborn bitches in law.
State's 28, what is that, Dr. Falzon?
State Exhibit 28 is a brown cardboard folder has a label marked with the unique case identification information, and this one is labeled anorectal swab.
Move to tender state 28.
Any objection, sir?
No, ma'am.
It is admitted.
State 29, Dr. Falzon, what is that?
29, again, is a cardboard folder with the unique identification label, and this is marked auto swab.
Move to tender state 29.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
That was 29, yes.
29, is that right, Dr.
Yeah.
Falzon? Okay, good. State 30, what is that?
30 is a white cardboard box, again, marked with the label with the unique case information, and this one is marked vaginal smear.
All right, we can
Move to tender state 30.
Any objection, Mr.
go
Cruz?
through some of these.
No, ma'am.
It is
I think I can zoom in. State 30, again, what is that, sir?
This is a cardboard folder and marked with the case information, and this would contain the glass slides with the smears of the vaginal taken by the vaginal swab.
How would
Okay, swab is
was,
crossed out and
State's Exhibit
smears
30
is written
created?
in.
The first we do the
Jesus.
swab. So, like I mentioned, you have the Q-tip swab that we insert into the orifice, in this case the vagina, to collect the fluids on the swab. Once that is removed, we take the glass slide and we rub the cotton tip across the glass slide to transfer cells from the Q-tip onto the smear, onto the slide, and thus creating a smear.
Thanks, sir. Then this is state 28. Again, I'm just going to show you the back of that sticker, then I'm going to flip it over. What is state 28?
That again would be the anorectal swab. Actually, this would be a glass slide, so that would be the smear.
And would that have been created in the same manner that you just described for the vaginal swab, smears?
Correct. So the swab would be inserted into the anorectal orifice, collect the fluid from that area, and then transfer it onto the smear, onto the glass slides.
Last, same question for state 29. I'm just showing the sticker there. What is state 29, just to be clear?
Oral
That
swab.
would be the oral swab. Again, this would be the smear made from the oral swab.
How do we know which one
Let's
is right?
talk a
though?
little
Is
bit
it an
about
oral
the
swab or a
swabs.
vaginal swab?
I'm going to start with state 25, which has been admitted into evidence. State 25, what is that?
It's marked auto swabbings B.
And then just for clarification, state 26. What are we looking at there?
This is marked auto swabbings A.
Dr. Falzon, I realize it's been a long time since. I guess let me ask the question this way: would you have collected 2 different sets of oral swabs back in 2001?
No.
What, if anything, can you attribute to the fact that 2 of those are labeled oral swabs and there is not one labeled vaginal swabs?
The swabs are collected during the course of the autopsy. As indicated in the report, I collected oral, anal, and vaginal swabs. Once the swabs are collected, as soon as they are removed, we take the swab tip and create the smear. So the swab is prepared, the smear is prepared, the smear is packaged. Because the swab is moist, if it is packaged right away, because of the moisture, mold grows on the tips of the cotton tips of the swabs. So the swabs have to be air dried prior to packaging. Every autopsy, the doctor has an assistant to help with the case. So the swabs would be placed in a small cabinet marked with the name, and it would be marked oral, anal, and vaginal. And the technician would package those swabs once they have air dried and package and label those.
Was that common policy and procedure at the crime lab back in 2001?
It was.
Bear with me, Dr. Falzon. I did want to go back and ask a few more questions about the fact that Ms. Baker had a broken hyoid bone, and you described what that bone is. Can you talk just a little bit more about the hyoid bone in general
So we're just
in a young person like Ms. Baker?
okay. It's interesting to me that in this testimony we're not talking about the fact that several of these swabs and or smears were labeled oral, but that the forensic technician who tests them later, I mean, I guess you can't ask this guy because they labeled them the way that they did when he did the autopsy. But once they get to the forensic lab in California, then they have to be relabeled as vaginal from oral because of the Lugol iodine test, which I'm still finding some confusion there. So it's like, They're only okay. So from what we talked about yesterday, they're only relabeling. They're only saying that these oral swabs were mislabeled as vaginal swabs because when they're doing the Lugol iodine test, that test is showing up with brown coloration, which brown coloration says that is it glycogen or it basically it says it should be a vaginal swab as opposed to an oral swab. But I'm saying that after 25 years and degradation, I don't understand how they can just be like, oh no, these are not oral swabs, which is how they were originally labeled. They are vaginal swabs. I just are you guys as confused about that as I am? I'm still trying to like sort of wrap my head around it. But now we're going back to the hyoid bone. So
The hyoid bone, like I said, is a C-shaped bone that sits just above the voice box. Initially, the bone is a little bit pliable. Young people have softer bones. As we grow older, that bone starts to get more calcified and become more brittle. So in younger people, you're less likely to see fractures of the hyoid bone as opposed to older people. But again, in this case, there were fractures both on the right and the left-hand side of the hyoid bone.
And based on that observation and your knowledge of that part of the human anatomy, do you have an opinion as to the amount of force that would have been necessary to break that bone?
It was a significant amount of force.
okay, so
And to follow up on that a little bit more, Dr. Falzon, you described the ligature previously, and the ligature marks on Ms. Baker.
the
Now,
ligature,
with
which
the
has
hyoid,
Chris Melton's
bone
DNA on it.
as well. Do you have an opinion as to, and again, taking into account all of your observations from Ms. Baker's autopsy, do you have an opinion as to the manner in which that strangulation with the ligature occurred?
Like I said earlier, the ligature encircled the entire neck. So it passed from behind, looped in the front, and then the ends of the ligature held on each side.
And anything about the
Also
existence
very
of those
personal.
defensive wounds on Ms. Baker's left hand that we previously described, is that significant in any way as to your findings related to the ligature?
I would say to the ligature. It's more in relationship to the
stack.
scap wound.
I understand. Dr. Falzon, those are all the questions I have for now. Mr. Cruz, last question, sir.
Mr. Cruz, cross-examination.
Thank you.
Yeah, you know what this reminds me of? Leo Bunker said the only mislabeled evidence, ironically, has Edric Faust's DNA in it. What this reminds me of is the 227 search in the Karen Reed case, when they had Ian Whiffen come in and create new Celebrite software that magically all of a sudden just erased that 227 search, basically. Sometimes I think that forensics, whomever they're hired by, they feel like they need to help make the case for whoever they're hired by, right? So when I hear things like the original swabs or the original smears that were sent to, so the originals took place in 2001, the day after Tara was found dead. Those would be the most reliable in that moment, right? So in 2001, they are labeling, they're doing all the things they need to do. 25 years passes, 24 years passes, and these 24-year-old swabs get sent off to a forensic testing company in California for some reason, not in Georgia. And it makes me wonder if they did that because this specific company still use the Lugol iodine test, which has been considered junk science for a while. And that's another way to appeal, by the way. I know that in the state of West Virginia, if somebody is convicted on something that is now considered junk science, that's a good appeal in the state of West Virginia. I'm wondering if that will come up in Georgia. But so now you've got a company that is being paid as experts to do forensic analysis for the state of Georgia. And they're saying, "Oh, well, this is crazy, but these swabs were mislabeled back in 2001 because we're seeing this on the test now." This is a 24-year-old old piece of evidence. And now we're seeing this. So these can't possibly be oral swabs. And it's like, even I'm a layperson. I'm not a scientist. I'm not a forensics anything. But as a layperson, I can be like, there's something seems very off about that. Something's off. So, yeah. It's like, I mean, they brought Ian Whiffen in to rewrite a program to get rid of that 227 search. That's what this feels like to me. Anyway, let's listen to Cruz's cross.
May I move the podium, please?
Right, absolutely.
Thank you.
He's just moving shit around. Okay. So.
Good morning, Dr. Falzone. Morning. My name is Attorney Ahmad Cruz. I have the privilege and honor of representing Mr. Edric Faust. Do you recall you and I speaking previously? Okay. Would you agree with the statement that Ms. Baker had a height of approximately 69 inches and weighed 113 pounds?
Correct.
Is it fair to state that Ms. Baker's earlobes were each pierced with a stud-type earring with a clear stone in each earlobe?
Correct.
They weren't taken, though, because there was no burglary.
Is it fair to say that Ms. Baker had blunt force trauma to the head?
Correct.
And you previously admitted that you took photographs of Ms. Baker's condition. Is that fair?
Correct.
I'd like to show you what would be marked as. Defense Exhibit 5. May I approach?
Your Honor, I would ask Mr. Cruz show me the exhibit report.
That's correct.
May I approach him?
Okay.
Is that photograph a fair and accurate depiction of Ms. Baker as you saw her?
Yes, it is.
Does that photograph, does that photograph appear to be altered in any way?
Not to my recollection. I can't say that I think it's an also no.
That's fair. Are those injuries consistent with the injuries that you witnessed on Ms. Baker?
They are.
Your Honor, I would move to admit Defense Exhibit 5 into evidence.
No, Your Honor.
It's in it.
May I approach Dr. Falzone? Dr. Falzone, you stated in your autopsy report that contusions also surround the anal region. Is that correct?
Correct.
And you identified the contusion as a 4.5 by 7 centimeter contusion that surrounds the anus. Is that correct?
Correct.
Keep in
I'd like to show you
mind,
what would be marked as Defense Exhibit 6.
the only DNA evidence found near the anal region was from Chris Melton.
Let the record
Even
reflect that I
though-
am showing the state what has been marked as Defense Exhibit 6.
Faust was charged with sodomy. Forced sodomy.
May I approach the witness, Your Honor? Let the record reflect that I provided Dr. Falzone with Defense Exhibit 6. Dr. Falzone, do you recognize those photographs?
Yes, I do.
Is it fair to describe that there are 2 photographs of Ms. Baker's anus and 1 photograph of Ms. Baker's upper body, chest to head?
Correct.
Would you agree that the contusions that surround the anus support that Ms. Baker was sexually assaulted anally?
Yes.
May I approach? Okay. Oh, here. Here, I move to admit Defense Exhibit 6 into evidence.
No, Your Honor. It is in it.
And I'd like to publish Exhibit 6. And just to make sure we're clear, these are photos of her anus and her upper body. Is that right?
Correct.
The state spoke with you about the packaging on state's exhibit. May I see those exhibits? Are those exhibits? On state's exhibit 25 and state's exhibit 26. And may I approach the witness, Your Honor?
Right.
Just to refresh you on what those are. And you recognize these from direct examination, correct?
Correct.
You stated that the way that these are packaged, and please stop me at any time if I say it wrong, I just want to confirm that I heard you correctly, that you get a vaginal swab, you then make a smear out of it, but because mold may get on the swab if you leave it out, mold may get on the swab because it's wet, you leave it out to air dry, and then a technician would package it up later. Is that correct? Did I say it correctly?
Correct.
Okay. The question I have for you, does no one check the technician when he labels or she labels the items to ensure accuracy?
Boom.
Not to my knowledge, no.
So, Dr. Falzone, is it possible? I'll ask you this way. If no one checks, how do we ensure what's in either package?
It should have O, A, and V in front of each and every swab, the respective swab.
If it's checked.
Obviously, it wasn't done correctly in this case.
Correct. Are you aware that it is extremely important to collect and store swabs a certain way if DNA is involved?
Correct.
Okay. And is it fair to say that if it's done
Yeah.
incorrectly, it could affect the results of any subsequent DNA testing of those items?
Absolutely.
Yes. Let's talk about the stabbing part.
In regards to the
find
way that
this
the swabbing takes
interesting.
place, for oral swabs, if you remember, did you do swabbing of the lips, the cheeks together, or is that something you would do individually?
It would be done individually. So we would put the swabs in the space between the cheek and the teeth, and then insert it into the mouth, into the oral cavity.
So one swab would start with teeth. Say it again one more time. I'm sorry.
In the space between the cheek and the teeth, and then insert it into the oral cavity itself.
Cheek
Okay,
and
but we don't do the area in front of the teeth and the lip.
No,
Okay. So teeth and cheek and oral cavity, I'm assuming, is just
inside the mouth.
Excellent. Thank you. In regards to the stabbing, I believe the state. Use your knife. I believe the state asked you to do a demonstration of your opinion of the way the stabbing took place.
Correct.
Is that the only way Ms. Baker's stabbing could have occurred?
Given the direction of the wound, that is the most plausible explanation for that. I don't know if you had any other explanations that I could assess as to whether they're plausible or not.
Well, I may have one, but the question I'm asking now is the demonstration that that was performed on direct. Is that the only way that the stabbing could have happened?
I mean, there could be other ways. I mean, if you had a left-handed individual,
So I'm left-handed, face to face, and if I was to do it this way, we would get the same result.
Essentially, yes.
Yes, it would. Huh. Could have been a left-handed person. This is always really interesting to me because the left versus right-handed perpetrator is really always interesting to me because again, I'm going to reference Pam Smart's case, so take a drink if you're into that sort of thing. It's always been said that Bill Flynn was the shooter of Greg Smart. And part of the issue there is that Bill Flynn was behind Greg Smart and holding him, and Patrick Randall was in front. And the way that Greg was shot, a left-handed person wouldn't have been able to do it. And Billy was left-handed. So there's a lot of conjecture out there that Billy wasn't actually the shooter, that Patrick Randall was a shooter, which would make more sense because Pat Randall was a lot more violent than Bill was. But there's no way to really prove that except for bullet trajectory, which they did in court and the jury didn't understand it. And in this situation, again, it's really important to understand, is the killer left-handed or right-handed? And the way that the prosecution just laid it out was, this is the only way this could have happened, was somebody standing behind her who is right-handed and stabbing her in the neck. And Ahmad Cruz is saying, well, I'm left-handed. If I stand in front of her and do this and point the knife this way, is that a possibility? And this medical examiner is saying yes. So the reason why it's good to have a good lawyer is because some lawyers wouldn't have asked that question. Some lawyers wouldn't have even thought about right hand, left hand. They would have thought, how do I get around the evidence that's being put out there by the prosecution? And I'm assuming, because of what Ahmad Cruz is asking, that Edric is right-handed. So, I mean, again, reasonable doubt for the jury that I think one of the things that we've got to do going forward as judges, as lawyers, as courtroom people in general, we have got to do better at explaining what reasonable doubt means to these juries. Because to me, we're on day 2 of this trial and we've only heard from, this is the 3rd witness. There's already so much reasonable doubt in this case. It's enough to be done with. Like, if I'm sitting on this jury and I hear what the firefighters say about no one broke into this house, there's no forced entry, somebody had to have a key or she had to know the person and let them in, and then this guy saying, well, we're not sure if the original evidence envelopes were mislabeled between oral and vaginal, which is 2 very, very different tests. And now he's also saying we're not sure if it's a left or a right-handed person. All of that is reasonable doubt. And this case is done on day 2. So What is this jury doing? What is this jury thinking? Ugh. All right, what are we doing here?
Objection about Exhibit 7 or 8.
Hold on.
Dr. Falzon, do you recognize Defense Exhibit 7 and Defense Exhibit 8 as additional photographs of Ms. Baker's anus?
Yes.
Are those fair and accurate depictions of Ms. Baker's anus as you remember?
Yes, but it also has the vulva with the burn injuries that I mentioned earlier on the direct.
Can I approach it?
The burn across the upper.
Where's the vulva?
That would be here.
What is this here?
That would be the anal region down there.
Yeah,
Well, you need to tender them. That's all right. Any objection about Exhibit 7 or 8? They are admitted and you may publish, Mr. Cruz.
Well, that would be the vulva again, different orientation.
Okay, all right. If the media would just turn their cameras off, we're going to post these pictures. Thank you.
Next witness said in the closing, I thought Cruz explained reasonable doubt pretty darn well. I think it's great that he explained it, but I think it would be even better hearing for the jury to hear that from a judge, because they know what he's asking them to do, which is find reasonable doubt. But if it comes from a judge, the judge is saying, this is your duty. You have to do this. And I just feel like the judges need to better explain what's going on. What are we sitting here doing?
I believe when you were on direct examination with the state,
Why is this?
and
so dark?
can you look over here, Doctor, just so I can point to it for you? You just resolution else.
What is happening?
Let's make it just a tad bit smaller.
All right, I don't know what's happening. All right, no further questions. There's going to be a redirect here, though.
Hi, any redirect, Mr. Bolden?
Briefly, Your
Go
Honor.
ahead.
Why is this not? Where is it?
Dr. Falzon, I think in connection with Defense Exhibit 6. Thank you.
Oh shit! I went back. This question, Darlene says, why did they not find it until they collected Edric's DNA? Point in fact, they set him up. Yeah, I feel like preliminary testing of the DNA, even just like standard DNA testing back then, if they were looking at this case from 2001 to 2000 and let's say 23, which is when basically the Athens County said, oh, we can't go any further with these suspects. Sorry. Sorry, I'm so sleepy today. We can't go any further with these suspects. So the case for us has ended. We're handing it over to the GBI. And this was after the law was enacted, named in Tara Baker's memory, where the only way the GBI could take on a cold case was if the local jurisdiction had said, we can't go any further with this case. Our leads are exhausted. Our suspects are exhausted, right? So from 2021, from 2001 to 2023, surely the DNA in this case was being thrown into CODIS to be like, are there any hits? Are there any matches? Are there any hits? Well, Edric Faust was in CODIS because of the felonies he had, or the felony he had. Why didn't his DNA pop up, even with preliminary DNA testing on oral swabs or vaginal swabs? Why didn't his DNA pop up before they sent it to this lab in California? That's my question.
All right, let me stop right there just a moment. Is there any response to the motion?
Wait. Sorry, we have a motion. What's the motion?
So for the record, oral swabbing B is labeled as item 2I, as in igloo. Oral
Am I
swabbing
in the
A
right place?
is labeled as item 2J,
14.
as in joy. So you're
No,
on.
Sorry, guys, I'm not in the right place here. My bad. All right, we got to get back to 210. 210. Okay. This is redirect by the state.
When you were asked a question about Defense Exhibit 6, I believe you were asked a question as something to the effect of, with the injuries to Ms. Baker's anus being consistent with sexual assault.
Why is he got to say anus
that
like
question?
that?
And just to be clear, would
Anus.
that also apply to the injuries that you observed to her vagina?
Could you repeat the question?
Yes. Would the injuries that you observed to her vagina also be consistent with sexual assault?
Correct.
And as it relates to either of those, does a sexual assault necessarily indicate that there's going to be the presence of any physical evidence recovered on that sexual assault kit?
Not necessarily.
What could be some reasons why that might be, sir?
I mean, one would expect to find DNA related to semen, but there may not be semen present there. I mean, the individual may not have ejaculated, a condom may have been used, a foreign object may have been used. So there's multiple explanations as to why DNA may not be recovered.
And are you familiar with the idea or the phenomenon of drainage, sir?
Fluids travel by gravity. So yeah,
that's all I was asking. Thank you. And then also on cross-examination, you were asked if the labeling of the items. The question that I heard was that if the labeling affects the results of the DNA testing. My question to you, sir, is think of the best way to ask this. Does the labeling itself, what is marked on a certain exhibit, have anything to do with the results of any testing of what is inside?
It would impact the interpretation of it.
Thank you, sir. That's all I have.
Any requests, Mr. Cruz?
Yes, ma'am.
Go ahead.
Same thing with Defense Exhibit 6. May I publish Defense Exhibit 6 for the jury, Your Honor?
Yes. How did you want to do that? On your computer?
No, I was just going to hand them.
That's fine.
May I approach you, Dr. Falzon? Thank you. And for the record, Your Honor, Defense Exhibit 6 was identified as Ms. Baker's anus and the upper area of her body.
Oh, jeez. Oh, jeez. Why is everybody got to keep saying anus?
But otherwise, Your Honor, I thank you. I have no other questions for Dr. Falzon. Thank you so much for your service, sir.
Thank you, Mr. Cruz. Mr. Bolden, any other questions of this witness? May this witness be excused? Any objection from the defense?
Okay, so I Live for Now said, I looked it up, and the June 12th hearing is for the motion on a new trial. There should be another motion filed closer to the June date with more details. Awesome. And we're definitely going to be covering those. That's why I'm glad we're doing this. We're going through this trial right now because we'll have this all done and understand. Well, at least I will. I wasn't able to go through it live with y'all when it happened live. So I'm glad that we can do this now. That being said, we've got another witness coming up. Let me just look at my notes really quick. Witness 2 is Catherine, Katie Lonstein, Athena Gray, Lieutenant Liel, Brian Grove. So we got quite a few witnesses left for the day. I think what I'm going to do, I need to take like a 10-minute break because I need to use the bathroom and grab something to drink. And then we're going to come back. I'm going to try to get through as many of these witnesses as I can. I think they'll go a little bit faster than the medical examiner because they're less, these are more like a fellow law student and a 911 training coordinator, and then crime scene investigator, and then ATF. So we might be able to get through all of these witnesses today. But I need to wrap this up around 5:30, 6 o'clock at the latest, probably. So when we come back, we're going to get into Katie Lonstein's testimony, but I need about a 10-minute break. So let's say it is 4:05. Let's say 4:15. I'll come back. I'm going to leave the stream up. So you guys feel free to also take a pee break and grab something to drink. I really appreciate y'all being here. There's not many people in today, but that makes sense because this trial's already happened. But tell everybody about it so the people who haven't seen it or who want to come back and talk about it or who have more insight, I want to hear from them. So tell your friends, share the video, share the stream, like it, do whatever you can do to help out with the algorithm. Yes, I will be back in 10 minutes. Okay, we are back. And I have Rubes in the pod with me. Say hi, Rubes. Why you look so nervous? Say hi to the people. Why can't you talk? I wish you could talk. Okay, I gotta go to work. You wanna get in your bed? You look so nervous. Why do you look so nervous? It's okay. All right. In the bed, please. Hello, everybody. Thanks for the little break. Oh, there's some new peeps here, and we lost some peeps. I know that the Rex Heuermann hearing is happening right now, so people are probably over there watching that. Or I guess you can't watch that, or can you watch it? Is that a state or federal? Oh, Amanda, hi, girl. What you doing? I thought you were on vacation. Are you still on vacation? Everyone say thank you to Amanda. She does our chapters for us, and she's amazing. I live for now. That's really sweet of you. Yeah, please post this. I want people to know that we are still keeping Edric in the light and trying to keep people interested in this case so that he can have as much support as he needs. So thank you for doing that. If you guys can repost it, share it, comment, like, subscribe, all that, it really helps. Oh, you're just taking a break from the Magic Kingdom. I hope you're having a good time. I hope the weather is good. We've had some weird weather here, although I hear in New England, you guys are getting snow, and I don't envy that. Oh yeah, the trial's in New York, and New York doesn't do cameras. That's right. So I think people are just reporting from inside the courtroom. I caught a little glimpse of the Rex Heuermann Long Island serial killer stuff, and it sounds like he is admitting his guilt, which good for the victims' families. I mean, what a mess. It's awful. Oh, let's see. Okay. So it's 4:15. We are back, and oh no. Yeah, I feel like who else is there? Someone from Maine. Who's from Maine? Here for the tea, I think, is from Maine. A lot of you know I grew up in New Hampshire before moving to Texas. I lived in North Dallas for a little bit. That's where I graduated high school. And then I got the hell out of Texas because Texas did not love me. And then I was in Boston not right after that, but I lived in Boston before here, just outside of DC for about 13 years. I was there when this whole Karen Reed thing started, and I didn't even realize it because I had so much going on, and it was the end of COVID. We were just getting, wrapping up COVID. So, I wish I'd started looking into the Karen Reed case as soon as it happened, but it took me a year or two to start thinking about it. Oh, thanks, Allie. Yeah, Texas. I haven't been back to Texas since, I don't know, must be like 97 or 98. Did not do well in Texas. Not as a young lesbian in Texas in the late 90s. Didn't go well for me. But I know that a lot of people love it in Texas, and Texas is giving me a little bit of hope right now with the politics. And I mean, the weather is pretty great. So I'm glad it's not snowing here. I'm sorry, New Englanders, that it's snowing where you are. It's not warm here just yet. It's pretty chilly still, although it's warmer today, but it's going to be 88 in the next few days, and I can't wait for that. So, okay, let's get back into this. We are moving on to Katie Lonstein, who was a fellow law student of Tara's. And let me skip ahead here a little bit. There we go. So I think this testimony, the last bits of testimony should go pretty fast, but I know that there's a bunch of procedural stuff happens. There's a lot of stops and starts in this court. So we are going to get through it all. Hopefully, I hope that we can get through all these witnesses today, but we'll see. Everybody ready? Let's do it. Let me bring this back up on the screen. And there we go. Okay. I want to say one other thing. Sorry to interrupt myself and the stream and everything. One of the things that I find interesting about this case too is that the people that knew Tara, a lot of them went to school with her and a lot of them were also studying law. And like this woman, she's an attorney, they understand this process and they know how to sort of get around some of the questioning. I found that testimony to be interesting with some of some of Tara's friends, because they're witnesses being called for the prosecution and they are Tara's friends, so they're on Tara's side. More than likely they're on the prosecution side. So I found some of their answers they felt it was like they were finagling it a little bit. You know what I mean? I don't know. I don't know if that's your thought, but that was my thought when I started thinking about how many lawyers are, witnesses in this case, or people who'd studied the law are witnesses in this case. Very interesting. Oh, wait, it's not even on the screen. I'm so sorry, guys.
Chip, can you talk to us about that?
Dumb.
Yes. Literally from that moment, Tara and I and another woman named Jenya became very good friends. I don't remember many
Let
moments.
me go back a little bit because I've just been sitting here listening to her testimony and not realizing that it wasn't.
But please speak towards the microphone, and if you would state and spell your name for the record.
Yes, my full name is Catherine Lonstein, Katherine Lahnstein, but everybody calls me Katie.
All right. Ms. Lonstein, what professional field are you involved in?
I'm an attorney.
Okay. And where did you attend law school?
Here at the University of Georgia.
And what
Weird
years
that
did
she
you
looked
attend
at the
school
judge.
at the University of Georgia?
2000 to 2003.
Before you got to UGA, where did you complete your undergraduate degree?
At the University of Virginia in Charlottesville.
All right. And in law school, can you describe the way during the first year of law school that the student body is divided?
Yes. So we're divided into 3 sections, X, Y, and Z. And you have all of your classes with the folks that are in your section for your entire first year.
And while you were in law school, did you ever meet an individual named Tara Louise Baker?
Yes, I did.
Okay. And when did you meet Tara?
Very first day of law school. We were in orientation, and that was the moment.
And so when you say that was the moment, it seems like it was a quick friendship. Can you talk to us about that?
Yes. Literally from that moment, Tara and I and another woman named Jenya became very good friends. I don't remember many moments of law school after that we weren't together, studying, walking, anything.
All right. So can you explain to the jury kind of the academic rigor involved in that first year of law school?
Yes, exhausting. You are in class 5 to 8 hours a day. Then you are studying another 5 to 6 hours a day. If you're lucky, you sleep some, eat some, but it is one of the hardest things I've ever done in my entire life.
That experience, and in particular, sharing it with the same people in every class, did you find that to increase or impact the way relationships were forged at all?
Yes, you form these bonds through the stress that you're going through. You're all learning the same thing. You're all studying the same things, and you're all exhausted in the same way. People would form friendships that would turn into marriages. People would form friendships that turn into lifelong friendships. It's just unlike anything I've been through before. It's like being in the trenches, I suppose, although, I don't know what way to describe it.
All right. And so would you say that would you characterize your relationship with Ms. Baker as falling into that category of relationships?
Yes, I would say from early on, I have called her one of my best friends. And I know it feels too short, but I don't know how to describe it other than if you don't go through that sort of very difficult thing with someone and it bonds you in this really particular way.
And as it relates, I think you've already testified to this, but there are 3 sections. You take all your classes with that section that you're in. Is that right?
Yes, first and second semester, your whole first year.
Okay. I'm going to show Your Honor, Mr. Cruz, what's marked as State's Exhibit 34. And Your Honor, I ask for permission to approach the witness and then continue to move freely through the well of the court as I question her.
Right.
So I'm going to hand you State's Exhibit 34 and ask you to take a look at that. Once you've had a chance to review it, let me know.
Yes, I have seen it.
Okay. Do you recognize it?
Yes, this is the schedule from our second semester, so beginning of January 2001 here at law school. Mm-hmm.
Does that appear to be a fair and accurate depiction of what your schedule was for that semester of law school beginning in January of 2001?
It does.
Judge, I move to tender state summary report.
Any objection, Mr. Cruz? It is in.
Your Honor, I'm not going to necessarily ask to publish this to the jury at this point, but I'm going to hand it back to Ms. Lonstein. As it relates to Fridays for y'all, did y'all have classes on Fridays?
Yes.
All right. And what classes did you have?
We had property property tort and civil procedure.
Okay. And property, was that the first class of the day?
Yes.
All right. And what time did that property class start?
9:30 in the morning.
And I don't think we covered this, but are you still practicing law?
Yes, yes, I am.
All right. Where do you practice law?
I live in Washington, D.C., and I work for an agency called the U.S. International Development Finance Corporation.
And so backing up now, back to January of 2001, I want to ask you about a Thursday evening, which would have been January 18th of 2001. Would you and Miss Baker ever study together?
Frequently, if not every day.
Okay. And so where would y'all study when you studied?
To the law library always, but there are different parts of the law library. There's this sort of first room you come into that has these big windows and it's very sun-filled, but it's a more casual part where people sometimes have conversations. So sometimes you would study there if you were doing a study group or if you were just reading and it wasn't too intense. And then there's this walkway you can go through and you go into the quiet part of the library. And that's where you would go if you were studying for an exam, trying to write a paper, trying to focus.
Okay. And so that evening on that Thursday, were you and Miss Baker studying together?
Yes, we were in the quiet part of the library.
Okay. And as best you recall, I recognize as we sit here, it's been over 25 years since that night. Do you recall about when Miss Baker may have arrived at the law library to study with you?
Yes, I think she got there around 7:30.
Okay. And do you recall what y'all may have been working on?
I believe it was a paper. It was definitely more than just like marking our law books because we both had our computers. So I believe we were writing something. And I know it sounds early because it was early in the semester, but that's just law school for you.
And as it relates to kind of that semester and Miss Baker's plans, was she approaching that semester with any kind of renewed or I guess elevated level of commitment to her grades?
Yes, absolutely. In fact, we all were, but she was the most organized. So she had a definite plan, whereas people like me were like, I'll try harder. But the end of our first semester was probably a bit of a shock to all of us, or, grades are hard. So her plan was to be more rigorous about her time in the library and to sort of make it into a job, like ending time, definite stay for the whole period.
And is there any particular ending time that you recall that Miss Baker was committed to?
Yes, it was 10 p.m.
Okay. So that evening, did you stay till 10 p.m.?
I did not. I had been at the library before. She had joined me there. So at that point, I was ready earlier than she was to go home. So I probably left around, I want to say around 9. Could have been a little bit later, but probably around 9.
Okay. And so was Miss Baker the type of person who had a lot of concern for the people around her?
Yes. I had to walk to school from based on where I lived. I lived just over the railroad tracks above where the Blind Pig Tavern used to be. And so not the safest of routes. So anytime I had left the library or school or anywhere before her, she would insist that I call her when I got home.
And so the area that you're describing, please correct me if I'm incorrect, but if you come down East Campus Road, going from North Campus to South Campus, and you turn left onto Research Drive, I believe it is, it goes by that area that you're talking about.
I think that's right.
Yeah, sorry.
No, sorry.
Go ahead. But I think I misnamed that street, but if you turn left underneath where the railroad tracks go over, is that what you're talking about?
It's in that direction, yes. It's actually been torn down and is a parking lot now, but that's the right direction, yes.
Okay. And so did she had that concern, did she ask you to do anything? Well, and that's going to call for hearsay. So I'm going to withdraw that question, Your Honor. Were you supposed to do anything when you got home?
Yes, I was supposed to call her when I got home, and I did not.
All right. And so did you receive a phone call that evening?
Yes, she called me about 9:30, maybe 9:45, and then she admonished me, scolded me because I had failed to call her, but I just didn't mean anything bad. I just forgot.
Okay. Do you need a cup of water? Or
Have some, thank you so
there's some
much.
tissues over there beside you if you see them and need them. Is that the last time you ever talked to Tara?
Yeah. I think the last thing she ever said to me was, I said, hello. And she said, you did not call me. And I said, I know, I'm so sorry. And she said, but you're okay? I said, I am. And she said, all right, I'll talk to you tomorrow. And that was kind of it.
So when you say I'll talk to you tomorrow, this was Thursday night.
Yes.
So tomorrow would be Friday, January 19th, 2001. Is that right?
Yes.
I would just object to your questions. I've given counsel leeway. I didn't want to just make.
All right.
I would ask the court to instruct them to ask.
Is he leading?
appropriate questions.
All right, I'm going to sustain that objection if you will rephrase your questions to be non-leading.
Yes, Your Honor. What day would the next day have been?
January 19th, 2001.
And what day of the week would that have been?
Friday.
Okay. And so on Friday, what would y'all's first class of the day have been?
I believe it was property
All right. And I think we already talked about this, but about what time did that start?
at 9:30 in the morning.
Was Tara in class?
No, she was not.
Was that something that was unusual for Tara?
It was. And we did, I recall my friends and I discussing it, but we thought, well, it's her birthday weekend. Maybe she slept in,
Okay. Did she show up for any of her classes after that?
No.
I would make the same objection. You can't read the questions. That the state asks questions appropriate.
All right, so the prior two questions were leading. I'm going to sustain your objection with regard to that and ask the state to make sure that you rephrase and you don't lead your witness. The last question was actually not a leading question, so I'll overrule your objection with regard to the last question. You may continue.
Thank you, Your Honor. So I think the last question I asked you is, did Tara show up for any of your classes that day?
She did not show up for any of our classes. No.
Okay. Were there any plans that y'all had for that evening?
Yes. As I said, it was her birthday weekend. So we had all planned to meet at a bar called the Winery just after class. And we did go. Her friends and I went, and she was not there.
Okay. When did you find out what had happened to Tara?
The next morning on January 20th.
So this is to establish
How is it that you learned about Tara's murder?
the
A
9:30,
friend of mine from law school named Jim
9:45
Davis called
phone
me.
call.
And he said, Katie, I'm so sorry, but Tara's died. And I yelled at him, and I was very mean. And I told him he was not funny. And then I hung up on him.
Okay, sorry. I just have one quick comment about this. I know that Ahmad Cruz doesn't cross this witness. I think that one question that I have that could have clarified a lot for the jury in this situation, and I'm not saying he did anything wrong, but in thinking about it, this woman's testimony is to establish that Tara called her, she said, around 9:30, maybe 9:45. The timeline that's been established that we talked about yesterday is that Tara left the law library at 9:45 and went home, and she was found dead the next morning. So whatever happened to her happened between 9:45 and the next morning. If the defense had gotten up and said, "Do you know where Tara was calling you from?" That would have established if Tara was still at the library, or if she had made it back to her apartment, or if she perhaps was at a Mexican restaurant, which is what the defense really wanted to bring in yesterday. So that one question, and the answer may have been, "I don't know," but it might have also opened up more questions as to, what was the rest of the conversation? Did she say anything about what she was going to do? Did she say anything about where she was? Did she say she was meeting up with anybody? Something like that. And instead, this testimony basically just establishes that 9:30, 9:45 this is the last person, it seems like, Tara spoke with that we know of. So a few more questions here would have really opened up some areas, I think. Because what we're going to see is, after the Cruz declines to cross-examine her, but there is a pretty large procedural argument and ruling that happens in here that is very important as far as I'm concerned. But we could have established a little bit more with this witness. So I just wanted to say that.
And then I called our friends. We called them the Erics because they lived in the same house. So I called the Erics, and one of them answered. And I said, "Eric, Jim has said the most insane thing to me. And he said that Tara died. So I need you to go get your paper and tell me he's wrong." And he did. He went out. And when he came back onto the line, he was just very shaken. And he said, "Katie, I'm sorry. She died. I don't remember her."
Any response, Mr. Yeoman-Shelley, with regard to the hearsay objection?
Ms. Lonstein, I think the court's instruction to you would be, in my instruction, is that please don't talk about in your answer anything anyone else said to you.
Fair enough.
Any objection?
I apologize.
She knows that because she's an attorney.
After that, I asked the friend that I was with to get me a newspaper. So that person did purchase me a newspaper. And then I saw the headline, Student Slain. And then the next thing I remember is I fell down, and then I started crying, and I don't know when I stopped, but that's how I found out.
I want to ask you a little more about your relationship with Tara. And I think, Jenya also seems to have been part of this group. Is that right?
Yes.
Okay. Would Tara share things with y'all that she didn't share with kind of the rest of the law school section and class?
That is my perception, yes.
Okay. Was there anything related to her last name that she shared with you that she didn't share with the rest of the law school section and class, to your
Couldn't
knowledge?
figure out why
Yes,
this is important.
to my knowledge, this
but-
was something she kept a little more private. Her name had been Barker. It was the name of the man who was her biological father, and she had changed it pretty close to law school, from my understanding, to Baker, which is the man she calls her daddy, his last name.
Okay. Were you aware of whether or not Tara was dating anyone?
Yes.
Okay. And who is that person, if you know?
His name was Chris. I'm sorry, I don't remember his last name, but yes, she was dating Chris, and she'd been dating him for a while, as far as I knew.
You don't
Did Tara,
remember his
and
last
I'm not
name,
asking you
really?
to get into anything Tara said to you, okay? But did she ever talk to you about Chris?
Yes, in a very normal way. We talked about our friends, we talked about our families, we talked about our relationships. I myself was in a relationship with at a time, so we shared stories like that.
What was, based on those conversations with Tara, what was your impression of their relationship?
That it was good. She was positive. She would smile when she talked about him. No, nothing except for happy.
I don't have any other questions. Thank you very much, Ms. Lonstein.
Cross-examination, Mr. Cruz.
Sorry for your loss, Ms. Lonstein. Your Honor, I do not have any questions, but I would ask if we could approach.
All right, may I approach?
Okay. So there's going to be, Cruz is going to ask the court for clarification on the 412 again. So this is interesting here what happens. Hold on a second. And like we talked about yesterday, this 412 issue, there was quite a bit of debate about it because the reason the judge held him in contempt in the opening statements is because he twice brought up, he first brought up the possibility that Tara could have been out having drinks at a restaurant after she left the law library. And that would open up the idea that she could have shared a drink with somebody, shared a cigarette with somebody, kissed somebody, possibly even had sex with somebody, that would establish DNA and quite possibly Edric Faust DNA. Who knows? The other thing that he brought up was that Chris Melton, in his interview, in his interrogation with police, had said that when they said, they were establishing the time frame of when Chris and Tara last had sex. And when they asked him about why there would be DNA, why it appears she did have sex during this time, he said something along the lines of, I'm paraphrasing here, he said something along the lines of, well, she must have been having sex with somebody else. Now, that is evidence, and that's in the record. And when Cruz brought it up, the DA lost his goddamn mind and told the judge that he should be held in contempt because it's a 412 violation. And the 412 violation is the rape shield law in Georgia, which means that you can't bring up any prior sexual history of a victim. Basically, you can't slut shame a victim. The judge held him in contempt because she said he didn't file a proper motion for 412. I want to make this clear for the record because in my research, it shows that Cruz actually did file a motion. He filed that motion for the 412 on January 20th prior to the trial. But when she said there wasn't a proper motion filed, what she meant was, as part of the 412 rule in Georgia, not only do you have to file a motion, you then have to have a follow-up behind closed doors, basically an evidentiary hearing, to talk about the statements that you would like to introduce, right? That hearing never happened. But as far as I understand it, it's not something that Cruz could schedule because he is not in charge of this court or this case. The judge is. I'm not sure why the 412 hearing after his motion wasn't scheduled. That's something that I'd really love an answer to. But that hearing never happened. So when she says you didn't properly file, and he says, yes, I did. And she says, no, you didn't. So I'm finding you in contempt. That's the issue with the 412 going into this trial. It doesn't seem like it was ever rectified. So what we're about to talk about here is Cruz being like, I just want to clarify for the record about this 412 issue because, okay, we'll watch it. Well, that's a really loud car. Can you guys hear that? D Cool says, I feel like the court isn't allowing an alternative theory of the crime, which makes no sense to me. Agreed. And the defense's theory, the defense is putting on a third party culprit defense, which means they should be able to bring in what they need to bring in about Chris Melton because that's who they've decided is the third party culprit. This judge is not allowing that, very obviously. There's also a woman who said, I Live for Now said, there's also a woman who says she saw her at the grocery store that afternoon and the items in her cart made her think she was having somebody over for dinner. Yeah, well, I don't know about that. That's really interesting to me. I know that when the DA objected during Cruz's opening to the line about the Mexican restaurant, that he wasn't making that up out of whole cloth. He wasn't just, pulling that out of his ass. That was an official tip that came in to the police department that a woman had overheard Tara talking at a Mexican restaurant the night before when she was supposed to already be home. the fact that the police department didn't follow up on that tip and didn't investigate that tip and what are you doing? And didn't get, like make sure that that tip was real or not real is not on anybody else but the 2001 police department. And it's in the case file. It's in the police file. So the idea that he brought that up without intimating any sexual anything, and that it was objected to, A, and that B, she held him in contempt over it, is just ludicrous, in my opinion. So, okay, here we go. Wait, you guys can't hear it? Can you hear me now? I can see my levels. All right, I'm going to play. Let me know.
Before our trial, I filed residual hearsay motions. The Honorable Court entered an order stating that I could not ask any witness anything about what Ms. Baker told them until, I believe you prefaced it on, depending on what Chris Melton's testimony was. You said you'll make a ruling after, I'm paraphrasing, you'll make a ruling once Chris Melton testified. You instructed me that in opening, I could not mention anything that Ms. Baker may have said to anyone. And as you know, in opening yesterday, I was held in contempt for making a statement that Chris Melton made that Honorable Courts, that Mr. Yalamanchili asked for, and Honorable Court granted, saying that I violated Rule 412, based on me stating that Mr. Melton stated she must have been with someone else when he was told that somebody else's DNA was found after he knew for 25 years somebody else's DNA was, or at least he was told DNA was present. Based on yesterday, I said, well, look, I need to be conservative. I don't want to offend the court in any way. I don't want the court to think I'm doing anything intentional when I'm not. So I assume that Ahmad don't speak on anything regarding Tara Baker's statements until the Honorable Court makes a ruling. However, Mr. Yalamanchili just asked Ms. Lunstein, based on what Tara Baker told you, what is your impression of the relationship? And I looked at the Honorable Court to see if the Honorable Court's going to say anything. Nothing was said. So that's why I came to the bench to just get clarity. And the only thing I want to do, Your Honor, I just don't want to offend you. I don't want to offend you. Yesterday, I got held in contempt, and I didn't even realize that I was doing something that was improper. So I'm trying to make sure I'm walking on eggshells for Your Honor. I'm trying to make sure I do everything right for Your Honor. So I just want clarity that if that question is okay based on the court's order.
She's going to
that's the only thing I want clarity on. Can I ask witnesses based on what Ms. Baker told them? What is their impression of the relationship with Chris Melton and Ms. Baker?
All right, Mr. Cruz, you are mischaracterizing the court's order completely. Yesterday's moments were based on a ruling that the court made on January 21st with regard to the state's appropriate filing of a 412 motion. And we've discussed this over and over again. And the court has noted over and over again that the defense did not file a 412 motion. The defense only acknowledged in open court to the state with regard to their motion that the only person that they would introduce or attempt to introduce evidence for with regard to any exception for 412 was Mr. Melton. And we've discussed over and over again the fact that should the defense wish to attempt to introduce evidence other than Mr. Melton, that a proper motion had to be filed. We've talked about that over and over again. Yesterday, I made a finding that you first attempted to circumnavigate that policy, that procedure, by insinuating certain things in your opening. The state made an objection. I sustained it. And I had a pretty lengthy discussion with counsel outside the presence of the jury, warning counsel not to do that. When you did it again, the state made an objection. I sent the jury out, and that's when I made a finding of contempt after allowing you certainly to explain it yourself. And I found that that was a violation of the court's order with regard to 412. And so your characterization to the court about what you're allowed to say and what you're not allowed to say is not does not comport with what happened yesterday. The motion that you filed, notice of intention to introduce residual hearsay testimony, is in relation to certain statements that you are asking the court to admit. They are pending. And they are pending because I made, and you appropriately said this, it will depend on how the evidence unfolds. And we will take up these motions again if necessary as the case proceeds. But there's nothing improper in the way that Mr. Yalamanchili asked that question. And it has nothing to do with 412. It doesn't have anything to do with my prohibition that I gave the defense. I think the insinuation that the court is being unfair and allowing one side to do something and the other side not to do something is absolutely mischaracterizing my order.
Absolutely
and so I'm responding to your comments, Mr. Cruz. If you have an objection to the state's questions, you certainly may present it right now, and I will make a ruling.
This is the situation the defense is in. I am handcuffed. Being held in contempt is a very severe sanction against an attorney. It is very severe. So what I have to navigate is being respectful to the court, also following the law, but most importantly, following the court's orders. The state, they have no prohibitions on him. I can't argue consent. The court said, well, you can't say anything about consent in regards to the DNA. Mr. Yalamanchili, who got up yesterday and said, oh, Mr. Cruz is so disingenuous. This prosecution is disingenuous. This guy's innocent. The evidence will show he's clearly innocent. So I won't go there. But we have restrictions on us that the state does not have. So what I have to do, because I've been held in contempt, is I have to make sure I don't do anything that'll surprise me like it did yesterday.
Okay, so Mr. Cruz, I would like to respond this way. Your characterization of being handcuffed, so you speak, is very unfortunate. And I think that is an unfortunate way to address the fact that the only reason that we're having this discussion is because you have not filed the appropriate motions for the court to take up. And the ruling that the court made about whether the defense can introduce a defense of consent and other things that you mentioned are because, and we have talked about this many times, that you have failed to file the proper motions. Because when you file the proper motions, the court will hear argument as to whether your motions are appropriate, as to whether the evidence you are seeking to admit is admissible. And if that is not done, then what you're seeking to admit is not allowed. And that is just the law. And so to characterize the court's allowing one party to do things and the other side being, in your words, handcuffed is not accurate. It is misleading. That is not why the court made a finding of contempt yesterday. I'm not going to go back over my finding, but suffice it to say, I think I was pretty thorough on the record twice about whether the defense was allowed to say certain things. The rulings that I have made that supported the court's comments yesterday are in the record. They are on the record. And Mr. Cruz, you are very well aware of the reasons that the court made those rulings. And so unless and until the defense files the proper motion, which would then provide the atmosphere for both sides to argue as to whether the evidence you're asking to admit is admissible, it is prohibited. And that is the law. And so I'm not going to argue with you about that. I think your characterization of what is allowed and is not allowed is mischaracterized. I can't think of another way to say it.
Your Honor, we gave 5 cases that 412 did not apply to a defendant saying that to a rape allegation, he's raising the...
I'm not going to revisit that moment, Mr. Cruz. I've already made my ruling.
Yes,
and so it is not appropriate to re-argue that your right in the court is wrong. There's another venue for that.
Yes,
I've made a ruling, and you certainly can take it up if necessary in another venue. But for now, I'm not going to revisit that ruling. I've made that ruling. And unless until you are filing the appropriate motions to be heard, and I've told you yesterday that if you do file those motions, even though they are not timely, I will consider them. But until then, my ruling does stand. And so I just need to ask you your objection right now so that I know that I've finally finished making whatever ruling it is with regard to what Mr. Yalamanchili was talking about.
So I didn't have an objection. That's why I approached the bench. The question that I was asking, because maybe I'm misinterpreting what the court instructed me to do and stay away from. I just want to know, because what I'm scared of is I ask the question, Mr. Yalamanchili hops up, Judge, he's done this on purpose, hold him in contempt again. I'm just asking, Judge, is it okay? We could have kept it at the bench. Is it okay? I just want to be clear. Is it okay if I ask witnesses the exact question? Based on what Ms. Baker told you and what she discussed in her relationship, what was your impression about Ms. Baker's and Chris Melton's relationship? Is that an okay question for me to ask?
Yes, it is, sir.
Yes,
That's what the state just asked.
Yes, ma'am.
Yes, sir.
Thank you, Your
And that was one of the moments with regard to that particular witness, Mr. Melton, that was basically properly noticed by the defense to the state because we had a hearing where we had that discussion. And so even though that notice was an oral notice as opposed to a written motion, we had that discussion in court. My ruling on the 21st was based on that acknowledgement by the defense to the state in proper form. So yes, sir. The answer to your question is yes. Mr. Yalamanchili, did you want to respond at all? I've been talking with Mr. Cruz, you're the other party. If you'd like to make a response, you may. And then Mr. Cruz, you'll have the last word. Go ahead.
Ding dong.
The court said the issue Mr. Cruz actually raised at the bench where the discussion started had nothing to do with 412. The court's already said we're not revisiting the long discussions. The court's reviewed all the cases, made its ruling in accordance with the laws of the state of Georgia. I just want to, establish for purposes of the record that Mr. Cruz filed a notice of intent to introduce residual hearsay statements. So asking to actually elicit hearsay from witnesses. The court withheld its ruling. I do want to say that at least, and I'll have a transcript in front of me, but I think Mr. Cruz has misconstrued the court's order as it related to that, which was we are going to hold rulings on this notice until such time as there has been testimony from the witness and some of the predicate requirements may be met about truthfulness. And then the court, obviously, it will be in your discretion even to admit or deny the introduction of those statements. So I just want to establish for the record, the state did not elicit any hearsay statement regarding Ms. Baker saying what it was about the relationship. We established foundation that this is a person who had discussions with Ms. Baker about her relationship, and we laid a foundation that they had a close and trusted friendship, and then just asked her about her impressions of their relationship. So I just want to make that clear for the record.
And I think that's an important distinction. So, Mr. Cruz, with regard to your question, let's go back to your question.
Did he help
your
you out there, Judge?
About eliciting information about the witness's impression of any status of relationship between Ms. Baker and Mr. Melton is certainly permissible. The state just asked it. The defense can ask the same thing. What neither party can do right now is elicit hearsay testimony. And let me just rephrase so we're on the same page. Because sometimes these things can get very technical, and I want to make sure that all parties are on the same page, and that is this.
Yeah, and
for
put
example,
it on the record
asking
that
the question
you
of
didn't
this
have
witness or
the
any witness based on what
in-camera-
Ms. Baker told you. Do you have an opinion on X, Y, and Z? At the moment, that's not a permissible question, right? Because it is eliciting hearsay. The way that Mr. Yalamanchili has just phrased what he asked this witness is permissible based on your relation. I'm not going to tell you how to make your question, but something to the effect of how he just phrased it, based on your relationship with a certain person, the hours you spent together, the things that you discussed. Do you have an impression of the relationship? That kind of a question is permissible. The state just asked something like that. The defense has every right to respond and ask the same kind of a question. But eliciting actual hearsay testimony is not permissible at this point. Does that make sense?
I agree with Honorable Court's ruling. I just wanted to make sure that I'm within the proper parameters and just let Honorable Court know, exactly where we're coming from as a defense. It's new ground when a prosecutor stands up and says, Judge, this attorney said something and he should be held in contempt and he's held in contempt. When the statement, again, that Chris Melton says she must have been someone else when confronted with DNA has nothing to do with 412. I am very familiar with 412 statute. That has nothing to do with 412.
We're not.
Go ahead, John.
Sit
I'm sorry,
down.
Judge,
He wasn't
just
finished.
because Mr. Cruz has
Oof.
directly referenced statements that I've made, I would just like to say I've never in my career as a prosecutor or a defense attorney, thankfully, until this trial, been put in a situation where I had to make that request,
fuck
but we were put in a
off.
situation where we had to make that request.
Blame the victim. Yeah, blame the victim.
For both parties. I'm not going to relitigate the moment where I've held you in contempt, Mr. Cruz.
Sorry, I'm
Yes,
getting
ma'am.
angry.
I am going to tell you that the comments that you have made, in my opinion, are mischaracterizing what happened yesterday. I'm not relitigating that moment. I'm going to ask that all parties move on. It is 5 after 12. I'm instructing both parties not to violate my ruling on 412. If there is a motion filed, even though it is untimely, I will consider it. But other than that, we need to move along.
The
So is there anything else, Mr. Cruz, you would
bullshit.
like to ask the court?
No, ma'am.
All right, thank you.
Your Honor,
Yes.
just to let you know, I am walking on eggshells. So if I have concerns about something, I'll just ask to approach the bench. It doesn't even have to be on the record. I just want to make sure I don't violate anything that honorable court puts in place.
Well, Mr. Cruz, I'm sorry to hear that. I don't know that walking on eggshells is a fair representation of what happened yesterday.
is.
I think the
It is
appropriate
fair
response
representation.
should be to review the court's rulings and just recognize what they are and not violate them.
Yes, ma'am.
All right, thank you.
How the fuck is he supposed to do that when you have so convoluted this entire process? Ugh. All right, I just want to reiterate, okay? This 412 issue is very complicated, and she keeps accusing Cruz of being disingenuous, but I think she's being pretty disingenuous herself. So she keeps continuously emphasizing that Cruz failed to file a proper 412 motion because of the rigid mandatory procedural steps required by Georgia's rape shield statute. And she's saying that these are steps that Cruz intentionally bypassed due to his underlying legal strategy. I think that is ludicrous, first of all, and also disingenuous. And here, this is exactly why the judge viewed Cruz's filings as procedurally, and I'm putting this in quotes because it's so ridiculous, procedurally improper. One, there was supposed to be a mandatory in-camera requirement, meaning, this is what I said before, the behind closed doors with the judge and the DA. Under Georgia law, you can't simply file a standard pretrial motion declaring your intent to introduce evidence regarding a victim's sexual behavior. This is all about sexual behavior. Like, the rape shield laws are to prevent slut shaming of a victim. Usually that victim is alive. And that I feel horrible that Tara is not with us and can't, speak for herself. But I want to be very careful about how I say this, because again, I've said this before, I'm going to say it again. I'm going to remind everybody, I'm speaking about this as from a place of somebody who's been sexually assaulted and sexually abused in my lifetime. I believe in rape shield laws. I do not believe that victims in a sexual assault or rape case should be slut shamed in order to prove that maybe they caused it or they brought it on themselves, because that's what this is about. That is not what he is doing here. And I think the judge knows that. And I think the DA knows that. And so the people who are being disingenuous in this situation are Judge Lott and Yamaman Bapadidabab. Okay. A proper Rule 412 motion specifically requires the defense to request an in-camera closed door hearing. Request a hearing. This forces the judge to evaluate the evidence in private before it is ever mentioned in open court, acting as a gatekeeper to protect the victim's reputation from being unfairly attacked in front of a jury. There isn't a jury on the planet, after hearing what the medical examiner just said about Tara's injuries and causes of death, who would sit here and think, oh, they're just trying to disparage the dead woman by bringing up her sexual history. No, her sexual history in this instance could prove one way or another if the man that's sitting in that chair on the defense's side should be imprisoned for the rest of his life times 2 plus 45. Okay. That's my opinion. Obviously, that doesn't go in line with the law. So let's stick with the law here. What she is saying is that one of the things that he didn't do is request an in-camera closed door hearing to go over evidence. He filed a motion. So she's saying that because he didn't take the next step to be like, and now we need a closed door hearing. That should be that's the next step. And the court has to be responsible for scheduling that next step. So if we're going to talk about disingenuous, there it is. That's disingenuous. Number 2, Cruz's January 20th filings. This is the filing that I keep talking about, right? Cruz did file pre-trial motions on January 20th, 2026, attempting to clear the way to use statements Chris Melton made about his physical relationship with Tara Baker, as well as arguments about how the DNA got there, right? So that could be the Mexican restaurant. That could be Chris Melton's statement that he, that maybe she had sex with somebody else, right? Chris Melton said that. Edric Faust didn't say it. The defense didn't say it. The DA didn't say it. The judge didn't say it. A witness, the other person who was the main suspect in this case for 23 years, is the one who said that. Kind of important. But because Cruz did not file a motion requesting an in-camera hearing under Rule 412.3, the fundamental legal disagreement is that he did not file the specific Rule 412 paperwork because his entire legal position was that the statute did not apply to his evidence. And the reason why he thinks that the statute doesn't apply to his evidence is because this is a constitutional violation of Edric Faust's Sixth Amendment right. Okay? Cruz argued he wasn't attacking Tara Baker's sexual character. He is not attacking Tara Baker's sexual character at all, in any sense of the word. Not this man. He is demonstrating Chris Melton's consciousness of guilt and exercising Faust's constitutional right to present a complete defense against a rape charge. To Cruz, filing a 412 motion would have been a concession that he was introducing character evidence, which he vehemently denied doing. Okay? This is all about, oh God, I'm so angry. I'm so sorry, guys. I'm fired up. This is all about the friggin' in-camera, well, I'm going to call it an evidentiary hearing. It may not even be called that, but behind closed doors with the judge in camera, that's what that means. The DA should be there. The defense should be there. He should present the statements that he wants to use, and then she should make a ruling on them behind closed doors. That one meeting never happened. He filed the motion to say, this is what I plan to say. So why wasn't the meeting scheduled? So Lisa Lott completely rejected his constitutional argument. Her stance was completely absolute, okay? And any mention of the victim's sexual contact or history, even to establish a third-party culprit, which is what the defense is trying to do, falls strictly under Rule 412. That is what Lisa Lott is saying. Therefore, in her eyes, because Cruz failed to file the exact procedural document requesting a private gatekeeping hearing, he failed to file a proper motion. When Cruz subsequently brought the issue up in open court during his opening statements yesterday that we watched that without that prior judicial approval, she viewed it as a deliberate attempt to circumvent the law. And that's why she held him in contempt for $1,000. If we're going to talk about someone being disingenuous, how about this? How about this judge? How about her saying, well, if you had asked for a hearing and we'd had that hearing, then you could do this. We'll schedule the fucking hearing. He filed the motion. I understand. I understand that if you want to go like literally by the typeface of the law, that he filed a motion and his next step should have been to say, I'd like to also schedule in camera. And because he didn't take that second step, he didn't feel that he needed to take that second step because in the motion that he filed, he said, this is a constitutional rights violation. It's not a Georgia state rape shield 412 violation. Nevertheless, I'm going to file it so you know what I'm going to ask. If that wasn't ruled on and there was no in-camera meeting scheduled, and he goes ahead and says the two things that he wants to say, which is there was a tip that came in about the Mexican restaurant, and Chris Melton is the one who said that she may have had sex with someone else. So if we're going to get down to the semantics of this bullshit, then we really need to talk about how disingenuous the judge is being in trying to act like he's not doing the proper filings. He's not doing the proper thing. He is chastising the court. He's trying to make the court feel bad because he's walking on eggshells. He is walking on eggshells. Look at this courtroom. And then what we're not seeing outside of our camera angle here, keep this in mind. The folks who, the lawmakers who wrote the law, Baker's Law, are sometimes sitting in the courtroom, sitting next to the jury. Okay? When it comes to a woman who brutally lost her life, and a man who is accused of that crime after 25 years based on one speck of DNA that is far less than the other DNA that is located on the victim's body in places where it looks like she was raped. We know she was raped. A man's life is on the line now, and we better fucking be sure that he is guilty. And if you're going to play semantics, like here's my thing. She keeps chastising Cruz in this moment for not filing the scheduling of the meeting, because that's what it comes down to. Why not in this moment be like, do you want to schedule this in-camera meeting? And if he says no, because I feel that my arguments are constitutional rights violations arguments as opposed to 412 arguments, then that ruling needs to happen. Am I wrong? Am I crazy? I feel like I'm crazy. Am I crazy? Is it me? Okay. All right. Let me just look at some of these comments and that'll make me feel better, I'm sure. The judge and the DA railroaded him, Ashley said. Agreed. I'm sure Tara would be outraged, Helena said. I don't want to speak for the victim, but people that testified for Tara said that she was sort of obsessed with justice. And I don't think she would think this is justice. I just don't. We understand about being fired up. I live for now, says. Yeah, I said, Kitty said she's so Auntie Bev coded. I said that Lisa Lott falls squarely in the middle of Auntie Bev and Judge McCarthy Neiman, who was in the Kelsey Fitzsimmons, who was the original judge, the one who sent her to jail when she was on house arrest. She's somewhere in between those two, and that's not a good place to be as far as I'm concerned. The formalities, the formalities should never interfere with the defendant's right to a fair trial. I agree. I believe and I understand that lawyers need to file the proper paperwork. They need to do the proper things. But you're sitting here holding someone in contempt for $1,000 and telling them that they haven't filed something properly, which literally is just scheduling a meeting, while the prosecution is presenting evidence that has been mislabeled for 25 years. They are presenting evidence. They're presenting evidence that is junk science. So let's do this to both sides. If you're going to do it to the defense, you got to do it to the prosecution, and you're not. So it's obvious. It shows us where your loyalties lie, as far as I'm concerned. Little Miss Flowers Shop said, I watched this whole trial. I'm so happy you're watching it and shining a bright light on this trial. I am happy I'm watching it too, although it's enraging. Okay, let's get back to it.
If you'll bring the jury up, please. Thank you.
Okay, jury's coming back.
Now that we are excusing that witness.
What are you on that sidebar for? One. The 911 coordinator is Miss Billy.
Thank you. Everyone may be seated. Mr. Yamachili, you have the floor.
Thank you, Your Honor. I believe Mr. Cruz indicated that he didn't have any cross-examination questions for Ms. Lunstein. I don't have any.
I'm not sure I heard that. Okay, so you were finished. Mr. Cruz, do you have any questions for this witness?
I hate his face. I'm sorry. I hate his face. So the next witness that comes up is Athena Gray. She is the 911 training coordinator for Athens Clarke County. She testified about the computer-aided dispatch or the CAD system. She verified the CAD report for 160 Fawn Drive from January 19th, 2001. And the initial call regarding the structure fire was logged at 11:22 a.m. The initial call regarding the structure fire was logged at 11:22 a.m. So the first call that came in about the fire wasn't until almost 11:30 a.m. Well, that makes the window of opportunity and the window where someone needs an alibi, that's much bigger. Okay, so let's move into let's move into Lieutenant Leal, who's a crime scene investigator. And then we have, I think, one more witness after that. So we should be, I think we got time. Okay, we got time. Everybody okay? Sorry if I'm ramping you all up. 4:35. Okay. Why are we at sidebar again? Hold on. What are we doing now? I wish I could read lips.
All right, Mr. Yamachili, you may call your next witness.
Yamachili. Okay, so we're going to skip over the 911.
Computer-generated information, I have no objection.
Your Honor, and I think defense counsel has actually filed a motion to this effect, but if we could limit speaking objections, please.
All right,
Oh, what? Wait. Oh, sorry. Hold on.
Your Honor, I would object to the statements that are in this document on confrontation ground clause, on the grounds of the confrontation clause. And that's to State Exhibit 35. As far as the computer-generated information, I have no objection.
Your Honor, and I think defense counsel has actually filed a motion to this effect, but if we could limit speaking objections, please.
All right, may I see counsel to the bench for a moment, please? Thank you.
I'm so confused. Okay, hold on. Let's just go back a few seconds here. What happened here?
Computer-generated information.
Number and the address that is registered to. Now, in order to create a call for service, we need to know two things. We need to know what the address is, and we need to know what the problem is. Once we get that information, then we can create a call for service in something called CAD. CAD is acronym for computer-aided dispatch. It's a system that we use to create the calls for services. As the call taker is gathering the information, they can enter that into the CAD system, and another person in the room will dispatch it out for service.
You hit on the next couple of questions I was going to ask, so you gave me a chance to skip down a little bit. Is information entered by the call taker and logged into CAD?
Leading.
Sustained. If you'll rephrase, Mr. Yamachili, don't leave your witness.
Well, Judge, I was going to ask a question that was about the testimony that she just gave. She just testified that the call taker enters information into CAD. And so my question was about that.
All right.
Well, that wasn't a question at all.
Okay. All right. So I'm just going to sustain the objection in the manner in which you asked it. I certainly will allow both parties to provide context to their direct examination questions or their cross if they choose to, but just make sure you don't lead your witness.
Thank you, Judge. Is the time that information is entered recorded in the CAD?
It is.
Okay. And is the CAD maintained?
Objection, Your Honor. Leading.
Right. I'm going to overrule that objection.
Is the CAD maintained in the normal course of regularly conducted activity by the 911 center?
It is.
Okay. And is that part of the regular practice of the center?
It is.
Are you familiar with the system that is used to record and maintain information for 911 calls?
I am.
And Judge, I'm going to show Mr. Cruz what's been marked. State Exhibit 35.
Your Honor, I would object to the statements that are in this document on confrontation ground clause, on the grounds of the confrontation clause. And that's to State Exhibit 35. As far as the computer-generated information, I have no objection.
Your Honor, and I think defense counsel has actually filed a motion to this effect, but if we could limit speaking objections, please.
All right. May I see counsel to the bench for a moment, please? Thank you.
Christ, they're just gonna squabble about everything. It's so ludicrous at this point. Okay, let's get through 911.
By 1:30, we're going to start testing.
Okay, there, lunch break. Move forward. Oh, wait, I have the time code. What am I doing? I'm just sitting here. Okay, 4:35. Okay, new witness.
Yes, sir. I believe I was. Okay.
Yeah, came right
And
into
did
this.
you receive any information regarding an incident at 160 Fawn Drive?
This is
Yes, sir, I did.
Lieutenant
I was
Leal, who's a
contacted
crime
by the
scene
division
investigator.
secretary that my services were requested at 160 Fawn Drive. And when you say your services, what particular services would those have been at the time?
To process the crime scene for the collection and preservation of evidence.
And so what did you do when you received that information?
I went to the scene and made contact with the officers and detectives that were already on scene, as well as a few of the firefighters, and discussed the situation that we had and began the process after the arrival of a GBI agent to assist, began the process of processing the crime scene for evidence.
And I want to pause for just a second and talk about something kind of separate from the crime scene itself. Do you recall what the weather was like on that day?
It was kind of cool and rainy. We have sections of heavy rain to mostly light rain, but I believe it's in the 50s, mid to low 50s, up to as much as 60 degrees.
Okay. And so when you arrived on scene, well, let me ask you this question first. Is there a typical process that you go through when you're about to prepare to process a crime scene?
Usually the first thing I'll do, I'll take video if it's necessary. We didn't do it on all crime scenes, but on the major ones we did. And then I would do photographing of the scene before anything was moved or disturbed. We would try to document the scene through photographs and video.
And so I'm going to hand you what's been marked as State's Exhibit 36 after I show it to defense counsel. Your Honor, I mentioned the principal witness to move freely through the well of court.
Granted.
Thank you. So I'm going to hand you what's been marked as State's Exhibit 36. Would you take a moment to take a look at that and tell me if you recognize what it is?
I do.
How do you recognize it?
It was presented to me by your office as a copy of the crime scene video downloaded to a flash drive.
Have you had a chance to review it?
Yes, sir, I have.
And does it, after having reviewed it, does it fairly and accurately depict the video that you created on January 19th of 2001 of the scene at 160 Fawn Drive?
Yes, sir, it does.
Judge, I move to send you State's 36 and publish it to the jury.
Any objection?
Hello.
It is admitted.
Mr. Leadall, while I'm getting this set up, 160 Fawn Drive, what county is that located in?
It's in Athens, Clark County. Is that better? Just-
Your Honor, I'm ready to publish State's 36 at this time.
Lawyer left on, I'm assuming that's what it's happening. There we go. Yep.
Okay, what are we doing here, guys? Oh.
Everybody has it on their monitor now? Excellent. Very good. Thank you, sir. You may proceed.
And Your Honor, just for the record, I've started the video back over at the beginning. And so I'm publishing State's 36 from the beginning. Thanks.
Oh, geez, Louise, you guys, come on. Move it along here. How crazy it is that the witness just gets to sit here and wait.
You and let me know when you have an opportunity to do so.
Yes, sir.
Do you recognize State's 37?
Yes, sir, I do.
And what do you recognize that to be?
It's an aerial photograph of the development at Fawn Drive and adjacent streets, including all the residences there.
All right. And are you familiar with that area of Athens during that time period?
A little bit, yes.
Yes, sir. Do you believe that is a fair and accurate depiction of that area during the relevant time period?
Yes, sir, I do.
Judge, I move to tender States 37 at this time and publish it to the jury.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
Your Honor, for the record, Mr. Cruz states 3839. May I publish this using the Elmo, Judge?
You may.
The
All right, counsel, we're going to take a 5-minute recess. And so, jury,
Oh, for
please go into the
fuck's
jury room. Don't discuss the case. We'll be with you shortly. Thank you.
Why? The amount of breaks this court takes, it just blows my mind. And I have a question for y'all. I know you all were talking about that podcast you listened to that came out. I think it was 2020, Classic City.
You have the floor.
Classic
Thank
City
you, Your
Crime.
Honor. I'm going to start calling you Lieutenant Leadall. Every time I say Mr. Leadall, it just feels weird to me. So I'm just going to refer to you as Lieutenant.
Oh, shut up. If you can put in the chat, if you've listened to it, what your thoughts are on it. Is it, I've just gotten an email. I'll just say this. I've just gotten an email from one of the creators who was asked, allegedly asked by Tara's mother to reach out to me to clarify some rumors and whatnot. I don't know. I haven't read the full email. I also haven't listened to the podcast. And I'm not here to disparage Tara. We all know that, right? I'm here to make sure they have the right guy who did this. And I don't really care about what Chris Melton did in his time between 2001 and 2024, 25. I don't really care what, where and when people went on dates and who, blah, blah, blah. What I care about is making sure that the right person is sitting in jail for this crime. And as far as I understand it, and from what I've seen so far, the right person is not sitting in jail. And I mean, I have a lot of sympathy for Tara's family. As someone who has been close to victims' families before and written their stories and done podcasts and told their stories through podcasts, I know it's really difficult, and there's a tendency you can get tangled up emotionally, and sometimes the relationship can become unhealthy. Sometimes it becomes too much for the person who's trying to tell the story. I've experienced that myself. I've also experienced being on the other side of it, being close to someone's family who's been convicted and been in prison for 35 years. So, and I've also been on the side of a sexual assault victim and their family, who I've told you the story before, but Veronica Rodriguez, who accused someone of sexual assault, and in order to make sure she had evidence, recorded audio of that sexual assault, and in turn the state turned the charges on her, and instead of charging the guy who sexually assaulted her with sexual assault, they charged her with a felony wiretap because she didn't get his permission before she recorded him. So I'm always very hesitant to talk to an advocate sometimes for a family who's like me, basically. I'm very open to talking to the family, obviously, but my question is, what are your thoughts and opinions on the podcast? Did we feel like it was one-sided? Did we feel like it was factual? What I'm starting to think is, the person who posted in the Facebook group might have something to do with these people, because it's interesting that I'm now getting an email today, uh, asking me if I want to interview this person who did the podcast. So tell me your thoughts and your opinions. Tell me anything you know. I don't know anything about these people. What I know is that I'm covering this case, and I'm covering it by watching the trial, so I understand what happened in the trial, so that I can make my own decisions about if Edric Faust is guilty, and we can talk out what happened in the trial. That's what I'm doing right now. I am not in any way trying to disparage Tara's memory. So anyway, would love your thoughts. Let's keep going.
Lieutenant Leadall from now on. Sir, you have States Exhibit 37, which has been admitted into evidence up on the screen there. Your Honor, would you enable the ability for Lieutenant Leadall to draw on the screen? Thank you. And Lieutenant Leadall, looking at that image, can you draw a circle around where 160 Fawn Drive is located?
Yes, sir.
All right. And so looking at that image, it seems to me at least, well, let me just ask you a question. Is there anything different about the roof at 160 Fawn Drive from the other roofs in the area?
Yes, sir. It's covered with a tarp.
Okay. And could you point out where Cooper Road is in relation to 160 Fawn Drive if you just draw a line across the roadway?
Yes, sir. This will be Cooper Road here.
Okay. I'm going to hand you now States Exhibits 38, 39, and 40. Same thing as before. Take a moment to look at those and let me know if you recognize what they are.
Yes, sir. I do recognize that.
And starting with States Exhibit 38, what do you recognize that to be?
That is a diagram of the floor plan of the residence at 160 Fawn Drive.
Who created that diagram?
I
I
did.
live for now. I would love to know more about what you're saying
Yes, sir, it
here.
is.
It doesn't.
Any objection, Mr. Cruz?
I don't quite understand it. So
last two as is.
Any response to the objection?
either
Oh, wait,
let me
you
know
mean
in the
39 and 40.
comments, or
Okay,
feel
let's-
free to DM me on
I don't
Facebook
know.
or
So we'll get to those in a
Twitter
second. How about 38?
email
What is your
me.
opinion on it?
I don't recall 38. May I ask you 38, just to ensure I don't.
Right, of course.
Objection to 38.
It is admitted.
States Exhibit 39, what is that?
That is a diagram of the bedroom.
Hang on a second, sir. I'm sorry. Yes, sir.
39 and 40 were the two that I had objected.
Okay, so we'll get to that in a minute. I'll let Mr. Yonachili lay a foundation if he can, and then if he tenders it, you can object and we'll hear it. Go ahead, sir.
States Exhibit 39, what is that?
It's a diagram of the bedroom where Miss Baker was located.
And who created that diagram?
I did.
And does it appear to be a fair and accurate depiction of the diagram that you created?
Yes, sir, it does.
And Judge, I'll move to tender 39 at this time.
Okay, Mr. Cruz.
I would object to it. You're saying that.
Okay, and tell me what you mean by that objection, and then Mr. Yonachili, you can refer to it.
Sure, just the descriptions.
Okay.
I remember correctly. That's it. Yeah, just descriptions. That's all.
Mr. Yonachili, any response?
Judge, I think that the description suggests that this is a demonstrative aid and it's created by Lieutenant Leal to depict the bedroom that he was in. It's not hearsay, it's his statements as a testified witness about what each of these things in his document are.
I'm going to overrule the objection and admit it over objection.
39 and 39.
We haven't got to it yet.
States Exhibit 40, Lieutenant Leal, what is that?
That is also a diagram of the bedroom where Miss Baker was found, and includes measurements to the location from reference points to certain areas on the body, as well as other pieces of evidence in the room.
And when you say measurements, who's making those measurements?
I did.
Okay. And does that appear to be a fair and accurate depiction of the diagram of measurements that you created?
Yes, sir, it does.
Judge, I'll move to tender 40.
Any objection, Mr. Cruz?
Yes, ma'am. Just present to the descriptions.
All right, anything further, Mr. Yonachili?
Same response. Same time, Judge.
I'm going to overrule the objection and admit it over objection.
And may I publish 38, 39, 40 to the jury?
You may.
Thank you, Judge. So Lieutenant Leal, starting with, froze up on me. Okay, there we go. Starting with States Exhibit 38, I would like you to start at the bottom of that diagram. Would you please just describe for the jury the layout of the residence at 160 Fawn Drive?
The layout starting at the bottom is the entrance into the front of the residence. And as you enter into the living room area, you'll locate two bedrooms to your left as you walk in, and one bedroom to your right, as well as the living room area. It also depicts the restrooms and the closets related to each bedroom. And then as you go farther into the diagram, you'll enter the dining area, and it's a floor plan of the kitchen area, the laundry room, and also shows a third bedroom and a rear entrance or exit,
Three
however you look
bedrooms,
at it,
3 baths.
to the
That's
residence.
pretty good.
Also located when you walk in the front door to the right is a bedroom, just off the living room, the bedroom, and it has its own bathroom.
As it relates to the video that we just saw, obviously depicted in that video was Miss Baker's body. Which bedroom is it that was located in?
She was located in bedroom number 3 in the upper left-hand corner of that diagram.
All right, thank you. Now going forward to States Exhibit 39. I'm going to point down, obviously there is a human-shaped drawing here. What is that?
That depicts the location of Miss Baker.
All right. And then there is an item that appears to be to the left as I look down of her head. What is that?
That would be a knife that was found on the floor beside the body.
All right. And then moving up towards the top of the document, what is the next arrow pointing towards and identifying?
That is the printer cable and power transformer that went from the printer to the body of Miss Baker, and the cord itself was wrapped around her neck.
And then as we move up, directly up from there, what is that arrow and what is it depicting?
That's showing the footboard of the bed. It was broken away from the frame of the bed. And then if you continue a little bit farther up there, you'll see the printer where that cable was run to.
And then I'm going to go to States Exhibit 40. What are we seeing here?
That's the same diagram. The only difference is I've added measurements from various reference points to certain items on the diagram, such as to the location of the body and of the bed, so I can put it back, the scene back together if needed on the measurements.
You mentioned taking a video and you mentioned also taking still photos. I'm going to hand you.
I really want to get to the hair.
After I show
evidence.
them to Mr. Cruz, what I'm going to label as states 41, 42, 43, and 44. On hand, you states 41 through 44. Take a look at those. Let me know when you've had a chance to review them. And then so on.
I viewed them as,
Starting with states 41, you recognize that image?
I do.
What is it?
It's a photograph taken of the entrance to 160 Fawn Drive.
And does that appear to be a fair and accurate depiction of the entrance?
Yes, sir, it does.
And I tender states 41, Judge.
Any objection, Mr. Cruz? It is admitted.
States 42, you mind telling me what that is?
That is also a photograph of the front entrance to 160 Fawn Drive, just taken from a different angle.
Does it appear to be a fair and accurate depiction?
It does.
Move to tender 42, Judge.
Any objection, Mr. Cruz? It is admitted.
And then as to states exhibit 43, what is that?
That's a photograph of the damage to the front door that was made upon entry.
Does it appear to be a fair and accurate depiction?
It does.
Move to tender 43, Judge.
Any objection, Mr. Cruz? It is admitted.
And 44, what is that?
44 is a photograph of the interior towards the right as you walk into the 160 Fawn Drive. It shows the living room area.
Thank you. Does that appear to be a fair and accurate depiction?
It does.
Move to tender 44, Your Honor.
Any objection, Mr. Cruz? It is admitted.
Your Honor, I've handed Mr. Cruz a number of other exhibits from the state for him to review. And I would just ask court to be allowed to publish states 41 through 44 for the jury at this time using the element.
Read it.
So states exhibit 41 being published now. Those hoses or tubes down at the bottom of the doorway there, Lieutenant Leadall, what are those?
That's
Those are
interesting.
Hoses that the fire department used to extinguish the fire.
Now going to states exhibit 42. I think you already stated that this is the entryway from a different angle.
Yes, sir.
No forced
States exhibit 43, do you mind
entry.
restating what that is?
That's a photograph of the lock and the handle on the front door showing the damage from the exterior side of the door.
When the firefighters kick the doors in.
And states exhibit 44. What is this again?
That's as you enter in the front door. It's a view of the living room to the right, all the way to the rear exit of the residence.
Let me see. Light might be helpful. Lieutenant Leadall, there on the coffee table, what are we seeing?
You see some books, and you also have some appears to be dust and soot, and possibly some fiberglass insulation on the table.
Okay. And so when you made entry into the residence and you were walking through, can you describe for the jury the condition of the residence outside of Ms. Baker's room, but the remainder of the residence as you walk through it?
It was kept very well. However, it did have a lot of sooting and dusty damage as a result of the fire and the debris from the fire, as well as some water damage, and also showing in this case insulation and some drywall from where the fire department had to open holes into the ceiling and pull some of the sheetrock down to vent up into the roof.
And so I'm going to skip around a little bit as Mr. Cruz reviews the other photographs that we're going to be admitting. What is trace evidence?
Trace
Been
evidence
on
is
for a
small
while.
pieces of evidence or minute pieces of evidence, such as hair, fingerprints, fibers, any very small pieces of evidence, even parts of bullet fragments, anything that's minute.
Can environmental factors at a crime scene impact the ability to collect trace evidence?
Oh, yes, absolutely.
Okay. And how so?
Well, like for example, when you're dealing with fingerprints and you introduce water to an area, that can help wash down fingerprints, or it affects the ability to recover fingerprints, because we typically use a powder to try to recover prints, and the water itself could cause damage to it and prevent you from recovering it. Also, you've got issues where you have, like in this case, the fiberglass insulation, blown insulation falling down. It would make it extremely difficult to recover hairs and fibers and things underneath that insulation. And it'd be almost virtually impossible to go through every little piece of fiber insulation to try to determine if there was any trace evidence attached to that. And also you've got temperature can affect, heat and humidity can affect the ability to recover fingerprints, and it also does damage to other items and makes it extremely difficult to recover trace evidence.
Did you end up processing this scene for trace evidence?
Yes, sir, we did.
Were environmental factors, I'm going to use the word factor twice, but what's the environment a factor in trace evidence processing in this case?
Very much so, yes.
What is a known sample?
A known sample is a sample that you get from a known source, such as an individual, or for example, if you're comparing paints, getting a known reference sample of the paint that to compare with the paint that you're finding, or something to compare with the item that you're collecting at the scene.
Is it important to collect known samples from people who have been at a scene as part of their normal life?
Yes.
Okay. And why is that important?
You can use it for process of elimination. Where you can, if you've got known samples of the people that live there, for example, you can use that to compare to the items that you collected at that scene to determine if it belongs to them or if it belongs to an outsider who may not typically have access to that residence or that location. So you would want the known samples to do those comparisons to eliminate some of the evidence that or trace evidence that you've recovered to see what you're left with and to compare it as a possible unknown.
Would it be expected or normal to find trace evidence from people who had been at a scene as part of their normal life?
Oh, yes, absolutely.
Okay. I'm going to hand you now state's exhibits 45 through 62. And instead of asking you one at a time, I'm just going to let you go through all of them.
Let's speed this up a little bit.
Judge Walden, typically I'll do Mr. Cruz state's exhibits 63 through 69.
Hey, Cassie, baby. Yeah, this is it's enraging for sure.
Kind of collectively, what are these exhibits 45 or 62 that I
They're photographs of the interior of the residence at 160 Fawn Drive, of the various rooms, as well as the bedroom area where Miss Baker was found.
and do they all appear to be fair and accurate depictions of various parts of that residence on January 19, 2001?
They do.
Judge, I move that tender 45 or 62 this time, publishing to the jury.
Any objection, Mr. Cruz? They are admitted. And your permission is granted.
Thank you, Judge. All right, I'm going to start with State's Exhibit 45. I've just put it up on the Elmo. Can you describe for the jury what's depicted in 45?
Yes, sir. That's as you enter the front door of the residence, that is to your right, and it shows the doorway leading to what I've labeled as bedroom number 1 on the diagram.
Thank you. And just for orientation purposes, I'll briefly put back up on the Elmo State's Exhibit 38. You said bedroom 1. Is that correct?
Yes, sir, that is.
All right. Then State's Exhibit 46. What are we looking at there?
That's a photograph showing taken from the front door area, going directly back to the rear of the residence.
God,
to your
such
left
a
would be the
90s
entrances
apartment.
to bedroom number 2 and bedroom number 3, where Miss Baker was located.
And I am going to show you 47 now. Is that just a slightly different angle of what's depicted in 46?
Yes, sir, it is.
And 48, can you tell the jury what that is?
Yes, sir. That's a photograph from the doorway entrance to bedroom number 2, which would, as you walk in the front door, that would be immediately to your left.
Okay. And I think the jury has seen the diagram. I won't do the reorientation again. Can we go to State's 49? What is that?
That is also a photograph of bedroom number 2, showing as you walk in the door of the bedroom, it'd be immediately to your right, and it goes back to the bathroom for that bedroom.
Messy.
State's Exhibit 50. What are we looking at here?
That's a photograph showing the kitchen area and the rear exit or entrance to 160 Fawn Drive.
Okay. And in particular, I'm pointing down at the picture to the bottom here. What is that at the bottom of the picture?
That is soot and water on the floor of the residence from the fire, as well as the firefighters and other personnel walking on the floor, disturbing that soot pattern. So it's just kind of mixed everything up.
But would that be something you would consider an environmental factor?
Yes, sir.
State's Exhibit 51. What are we looking at here?
And that is a photograph of the entrance to bedroom number 3, which is Miss Baker's bedroom. And immediately to your left is a shot of the doorway going into the bathroom there that enters into that living room that is also shared through Miss Baker's room.
Sir. State's Exhibit 52 here. What are we looking at?
That's a photograph from the doorway as you enter into bedroom number 3 or Miss Baker's room, showing the wall immediately to your right as you enter.
And I'm going to point down here. What is my finger pointing at there?
That is the computer printer.
There are going to be some difficult pictures. Obviously, we've all seen the video. I'm putting up State's Exhibit 53 at this point. What are we looking at in 53?
That's a photograph showing the position of Miss Baker as she laid on the floor of the bedroom.
Okay. Right here is, what is that?
That is a strap that belongs to either a purse or an overnight bag or something that's immediately below the left hand of Miss Baker.
And it's difficult to see, but I'm going to point here. And then, Judge, if I could circulate this picture to the jury. What is that around her neck?
That is the printer cable, the power cable that leads from the transformer of the printer and is wrapped around the neck of Miss Baker.
Judge, if I could, just because it is difficult. State's Exhibit 54. What are we looking at there?
That is also a photograph of the printer that's on the floor. And also you'll see the edge of the footboard of the bed on the left side of that photograph.
And so for orientation purposes, I'm putting State's Exhibit 39 back up. So as you come in the doorway to the bedroom from the hallway, which way would you turn to see the printer that was just depicted in State?
I'm going to pause this for a second because it's getting close to being time where I have to jump off. But I'm going to go through He basically takes us through all the evidence that is around, like the physical evidence that is around Tara's body. So he documented the printer cord, the knife near Tara's head, and a blood transfer pattern on her right leg. He also attempted to lift a print. He was attempting to lift a print from the bloody pattern, but failed to do so because of heat drying the skin and water from the fire hoses. So it would have, I think it was a print from her leg, lift a print from, like a handprint was on her leg. He tried to get fingerprints. He tried to, you know, find some sort of a blood spatter pattern, all that stuff, but he couldn't do it because of the fire, basically. He also found white marks near the front door peephole and stove. Very interesting. Indicating surfaces had been wiped with a rag. And then he found trace evidence. This is what I wanted to get to because I want to get into the cross-examination here. He collected hair from Tara's torso, buttocks, and left hand, and he placed them in sealed evidence envelopes to be sent to the GBI. Okay. So let's move into the cross because I think the cross is, I mean, we know what was found at the scene, but I want to understand more about this evidence and how it was packaged and labeled and all that stuff. So let's get into, want to be on another sidebar here? No. Yes. No. Yes. Hold on. Okay.
We have a box for you. We left it downstairs, Ms. Satterfield.
It's very loud in that courtroom. Let's move it up. Move it up. Move it up. Its head snorts. Okay.
And you have continuing freedom to walk around the courtroom. You don't have to ask.
Okay. So this is the cross-examination of the crime scene investigator.
View of the Deer Park community. Is that correct?
Yes, sir, that's correct.
Okay. And I would like to also show you what's marked as defense exhibit 12, 13, 14, and 15. And let the record
There's some
reflect,
pretty
I may have
dramatic
skipped,
moments that are about to happen
9,
here.
10, and 11. These are marked. Let the record reflect that I'm showing the state said as it is. Lieutenant Vidal, take your time, look at those photographs. Once you've had opportunity to look at those photographs, just please look up. You recognize defense exhibit 12 through 15, if I have my numbering correct, as aerial views of the Deer Park community. Is that correct?
Yes, sir, they are.
Okay. And they're aerial views from different angles. Is that correct?
Yes, that's correct.
Are those photographs fan accurate depictions of Deer Park and the surrounding area as you know it?
Yes, sir, they are.
Thank you. Have those photographs been altered in any way to your knowledge?
They don't appear to be, no.
Yes, sir. Your Honor, I would move to admit defense exhibit 12 through 15 into evidence.
Any objection?
No objection, Judge.
They are admitted.
You want 37 back?
Oh, it's about to get dramatic.
I'd also like to show you State's Exhibit 47. We've established that you recognize State's Exhibit 47. Is it okay if I approach you, sir?
Yes, sir.
We have established that you recognize the photographs. Is that correct?
That's correct.
I'd like to show you court's indulgence, Your Honor.
Court's indulgence.
Yeah, I won't be starting.
So I handed you the state's exhibit and I handed you defense exhibit
Scratched
9.
his head
Would you
with
agree that defense exhibit
gloves
9
on.
is a close-up of the window depicted in state's exhibit, I believe 27, if I'm not mistaken. I may have that number wrong. 47, please forgive me.
Yes, sir. You're correct.
And do you recognize that photo?
Yes, sir. It's the photograph showing the window adjacent to the rear entrance or exit, however you want to look at it, to the apartment.
Yes, sir. Has that, to your knowledge, or would you have any reason to disagree that that photo has not been altered in any way?
I would agree.
Your Honor, I would move to admit defense exhibit 9 into evidence.
Any objection?
No objection, Judge.
Admitted.
Yes, ma'am. And I would ask for permission to publish defense exhibit 9 and state's exhibit 47 to the jury. Thank you. I'd like to show you what is being marked as defense exhibit 10. Let the record reflect that I am showing the state what has been marked as defense exhibit 10.
Absolutely.
Do you recognize defense exhibit 10?
I do.
And you recognize defense exhibit 10 as the back door that's depicted in state's exhibit 47, is that correct?
Yes, sir, it is.
It's just a closer up view of said door, is that right?
That's correct.
Would you have any reason to disagree that that photo has not been altered in any way?
Doesn't appear to be altered that I'm aware of.
Yes, sir. Is it a fair and accurate depiction? The back door you remember to be?
Yes, sir.
Your Honor, I would move to admit defense exhibit 10 as evidence and publish same to the jury.
So we're just admitting evidence right now. We can't really see what it is, so we're going to move through it pretty quickly.
Where's the other jury?
Dean, what are you doing?
I'll show you what's been marked as state's exhibit 71. Now, in regards to state's exhibit 71, I believe we saw a prior photo of material from the ceiling that was on top of Ms. Baker and on top of the item there. Is that correct?
Yes, sir.
Okay. And just to make the record clear, the item I'm speaking of is the power transformer. Where the power transformer is located, once that debris was moved, is that the place that you found the power transformer located?
Yes.
Don't keep doing
Can I
that.
ask for permission to publish state's exhibit 27 to members of the jury?
That was already admitted, correct?
It was.
Thank you.
Thank you. And we've already established that on January 19, 2001, you went to Ms. Baker's home and you had opportunity to view her body, correct? Would you agree?
Yes, sir.
Here it comes.
In regards to the evidence located on and around Ms. Baker's body, there were hairs collected from Ms. Baker's left hand. Is that correct?
Yes, sir.
There were hairs collected from Ms. Baker's body. Is that right?
That's correct.
Yep.
There was also a hair collected from Ms. Baker's buttocks. Is that right?
That's correct.
Good girl. I'm getting
And
nervous.
I'm going to get you another pair of gloves.
No, I'm good.
Well, you already
Give me one
scratched your
second, portion
head.
of
I
this.
mean, you shouldn't be touching anything because you've been scratching your head with those gloves, sir. Here we go. Why does he get his face all red?
All right, I'd like to show you what's been previously admitted as State's Exhibit 89, which contains a envelope enclosed, documented as item number 8, hair from buttock. Do you recognize that?
Yes.
Hair from buttocks.
I'm going to hand you a pair of scissors. I would like to open item number 8 that was within State's Exhibit 89. And I provided you a paper
Mama.
towel for the hair.
Okay.
Here comes the drama.
There is no hair in it.
I can't believe he just tried to dump it
Can you
out.
repeat that?
There is no hair inside it.
Thank you.
Why would he try to dump it out?
Place this back in the envelope. I cut it open.
Oh, yeah. This is worse than Yuri pulling out the wrong shoe. You're absolutely right, next witness. Why is there no hair in the envelope? Where's the hair? Where's all that Caucasian hair?
I'd like to show you what's previously been admitted as State's Exhibit 88.
I don't think the jury
Inside State's
understands what's
Exhibit
going on
88, there's
here.
an item, there's an envelope marked number 9, hair from torso area of victim. Are you okay with opening this for me, sir?
Yes, sir.
So dramatic. So dramatical. Don't blow in it. Don't dump it out on the table. No. Oh my God.
There's no hair inside here.
Can you repeat that for the jury?
There's no hair inside here.
Jesus. Keystone Cops. Fucking Keystone Cops. Did you see his face?
Bathroom break if it's okay.
Yes, you can.
Bathroom
Ladies and gentlemen,
break.
I'm going to ask you to go into the jury room for a couple of moments. Please don't discuss it.
Why? Why bathroom break? George.
Please be seated. Mr. Chris, you have the floor.
Thank you, Your Honor. Lieutenant Liao, did you collect hairs and put them in those envelopes?
Yes,
Okay, so at one point in time, there would have been hair in those envelopes. Is that correct?
that's
What
correct.
did the GBI
Thank you,
do
sir.
with them? What did the GBI do with them? Where are the hairs? Where'd the hairs go?
All right. I'd like to show you what's been previously admitted as State's Exhibit 90, which is hair from left hand of victim. And inside State's Exhibit 90 is a white envelope marked number 10
Completely agree.
with a
Nick
description of
Whitney.
hair from left hand of victim.
This should
Madam
have
Clerk,
been
can you
an
open this for
instant
me?
mistrial right here. This is the hair that's supposed to be in her hand. The Caucasian hair in her
Looking
hand.
at that exhibit, I would like to mark empty envelope number 8, which is the envelope that was supposed to contain the hair from Ms. Baker's buttocks, as Defense Exhibit 11.
He's putting his own stickers on. Lefty.
Which I'll separate from State's, I think 27.
Yeah.
Sorry, which I
Yeah,
separated from
feeling that.
State's 89.
Are you asking it to be readmitted, or are you just putting a defense number on the already admitted exhibit? You want it on the envelope? Okay, and it's number 11. All right. So, any objection, Mr. Yeoman-Chili?
I don't have an objection. I think the original larger envelope and its contents have already been admitted. However, I don't have any objection to
All right.
labeling the interior envelope.
You have no
I will admit it
shame.
in that
You have
manner.
no shame in
Yeah.
this moment.
Also,
right
the
here?
envelope that was in State's
No
Exhibit
shame.
88, which is the empty envelope containing, well, that would have contained hair from the torso of the victim. I am admitting this as Defense Exhibit 16, Your Honor.
All right, Mr. Yeoman-Chili, any response?
Just the same response, Your
All
Honor.
right, I will admit it. Okay, it has been, the whole package has been admitted as State's exhibit, but I will admit it as defense 16 in this manner, without objection.
Y'all have no shame.
Lieutenant Liedall, can you tell me the number of hairs that were in State's Exhibit 90?
From this, none. There was 0 in here.
There are no hairs in State's Exhibit 90?
That's correct.
Did you put hairs in the envelope when you sealed it up?
Yes.
Yep. Where is it, GBI? Where are the hairs?
Your Honor, I would like to mark as Defense Exhibit 17, the empty envelope that would have contained the hair from the left hand of Ms. Tara Baker.
Any objection, Mr. Yeoman-Chili?
No objection, Judge.
All right, I will admit it in the same manner as before, without objection.
Ugh. If I were sitting in Edric Faust's chair, I'd be
In regards
losing
to your
my
observation of Ms.
goddamn
Baker's
mind.
home, is it fair to say that you determined that Ms. Baker's front door was deadbolt locked before it was opened by firefighters?
It appears that way, yes.
You would agree that there were multiple bedrooms in Ms. Baker's home, correct?
I hope
That's
the
correct.
jury
And they
doesn't
belong to Ms.
understand the
Baker's
significance
roommates,
of what
Ms.
just
Ashley,
happened.
at the time, Ms. Ashley Peavy, now Mrs. Ashley Peavy Hall, and at the time, Ms. Valerie Lowe, now Dr. Valerie, excuse me. At the time, Ms. Valerie Lang, now Dr. Valerie Lowe. Is that correct?
That's correct.
Based on your observations, none of the drawers in Ms. Lang's room appeared to be disturbed.
That's correct.
Based on your observations, none of the drawers in Ms. Peavy's room appeared to be disturbed.
That's correct.
Would you agree that Ms. Lang and Ms. Peavy had jury boxes, computers, and other accessories in plain view within the home?
That's correct. There was.
And of course, I'm sure we agree on this, none of those items were taken from the home.
That's correct.
You also had the opportunity to walk through the living room and the common area of the home. Is that correct?
I did, yes.
Would you agree with the statement that nothing was stolen, that nothing appeared to be stolen from the living room or common area of the home?
I can't say that with any certainty since I don't live there and don't know what is actually there, but there were items still present.
Do you recall writing a report dated January 21st, 2001?
Okay.
I do.
Do you have a copy of that report there with you?
I do, yes.
Can you turn to page 3 of 11?
So there's not a lot that happens after this, except for, well, for testimony anyway. But the DA redirects and says, "Hey, did you put those hairs in the envelopes?" And then you handed them off to the GBI, and he says yes. And he says, "Do you have any idea what happened to those hairs?" And he says no. But what is the judge thinking here? You're trying a man for heinous, brutal murder and sexual assault and robbery or burglary, and there's evidence missing and no one knows where it went, and that's not an immediate mistrial? Because the defense has been sitting here saying those hairs, all the hairs on her butt, the hairs on her torso, the hairs that are clenched in her fist, that all those hairs are Caucasian hairs, not African American hairs. So where are the hairs? That's evidence that would prove physically that it wasn't Faust, in my opinion. So let's move on. There was one last thing. I think there was only 2 minutes left of this testimony with the redirect. And then I think there's an objection or there's a motion.
All right, Mr. Cruz, your motion. Go ahead, sir.
I would just like to renew my motion in regards to, and I'll say motion to eliminate, to admission of testimony that the oral swab B is a vaginal swab. The additional information that I'm providing to the court is consistent with our prior argument that regarding the collection of that swabbing and the markings of that swabbing, and what Dr. Falzone testified to in regards to the procedure, as well as the supervision of making sure items are properly marked and properly identified. As the court saw, we just had, I believe it's 3 envelopes. One was supposed to contain, was marked to contain hair from Ms. Baker's hand. Mm-hmm. And we heard testimony from the Honorable Lieutenant Leadoff that he collected it, he put it in the envelope, it is now missing. We also had a hair that was identified that was on Ms. Baker's butt that the Honorable Lieutenant Leadoff stated that he put in the envelope, it is now missing. And we also heard about the hair, you also heard testimony about the hair that was on Ms. Baker's chest that the Honorable Lieutenant Leadoff secured, packaged up, it is now missing. I would ask the Honorable Court to consider that in regards to our argument regarding the oral swabs. And 23 years later, the state is going to attempt to introduce testimony that these oral swabbings are now vaginal swabs. Thank you for hearing me out, Your Honor.
Thank you. Mr. Golden, Mr. Yelmichili, any response?
Yes, Your Honor. I think Mr. Cruz is confusing admissibility of the evidence versus the
Jesus.
I guess the significance of it. It's hard to really understand. I would point out that we had the motion, motion in limine, whatever he characterized it as, when Dr. Falzone was on the stand. But then when I actually moved to tender the exhibit, there was no objection. So there's no contemporaneous objection to the admission of the evidence. I think, again,
Mr. Cruz, it's your motion. I'll let you respond when he's finished.
Yes, ma'am.
Respectfully to Mr. Cruz, I think he's misunderstanding the fact that there will be additional testimony about not only the items that Lieutenant Leadoff just entered into evidence, but also those that Dr. Falzone entered. You can't have one witness testify about everything as it relates to the piece of evidence. That's why you tender it and then have them testify. So I don't know what the grounds are that he's asking to move to exclude the exhibit relative to oral swabs A, but they're admitted into evidence, Your Honor.
Thank you. And thank you.
If I may, Your Honor, as I mentioned when I learned about the swabbings today, this is a motion that I brought up as this issue came to my attention. If the Honorable Court is willing, we're coming tomorrow to provide the Honorable Court with cases. And just to clear up Mr. Bowden's, if I misstated anything. So when it comes to chain of custody, the state has to establish an appropriate chain of custody before evidence is admitted. If not, if there's an issue with the chain of custody, and I provide Honorable Court with a case or cases regarding this issue, that evidence is to be excluded. We have a chain of custody log. And one of the biggest issues with the chain of custody log is the same way those items were packaged here today. They're the same way on the chain of custody log. And I said, well, maybe because it was improperly marked, they just put it in this way. But actually seeing the packages ourselves, and I should have opened it. I didn't even think about opening it to see if something's actually in the box. I would just ask the Court to allow us to have a hearing. I'll present the case law Pursuant to chain of custody, I'll be able to present the chain of custody report to the Honorable Court. And the Honorable Court has already heard testimony from Lieutenant Leadall about what he collected and what's missing. And I think it would be appropriate, if the Honorable Court finds that it is appropriate, to allow us to present that issue to you in regards to suppression of any future testimony that is now attempting to relabel swabs that have been documented as oral for 23 years to now say they are vaginal swabs.
Thank you.
Thank you, Your Honor.
All right, so I'm going to deny your motions, Mr. Cruz, and this is the reason for them. You are asking the court to kind of venture into the purview of the jury. There has, first of all, I agree with the state that the evidence you are complaining about with the doctor expert we had this morning was admitted into evidence. The issues that you're referring to right now with regard to any evidence that has been admitted with this witness goes to the weight of that evidence. And the argument you're making about about chain of custody is an argument that you are entitled to make to the jury if you choose to do that. But what you're arguing is the weight of the evidence. And so I'm going to deny your motion, Mr. Cruz.
Yes, ma'am.
All right, thank you.
One question for you, Your Honor.
Yes.
May I follow up with a couple of questions for Lieutenant Leadall, separate from our motion, but once the jury comes back out?
So hang on just a second. I'm trying to remember where we were before I sent the jury out. Did you finish your redirect?
Yes, Your Honor.
Okay.
I asked a single question, or
Okay.
single question, but 3 questions, I think.
Right, and I have not yet asked you if you had any recross. Is that correct?
He indicated he did not have recross, and thank Lieutenant Leadall for his service.
Okay, that's correct. All right, I'm going to deny your motion, Mr. Cruz. Can you bring the jury out, please?
Wow.
I do remember that now.
Wow. Yeah, she needs the DA to help her. She needs the DA to help her judge this case, I guess. I know that, yeah, Defense Diaries is going to do the Kelsey breakdown. Rebecca and I did 2 nights ago, the new filing from Justin Alien in the
Musical chairs.
Kelsey Fitzsimmons.
All right, you all may be seated. Thank you. All right, may Detective or Lieutenant Leadall
family
be excused?
probate.
We'd ask that he is, Judge.
Any objection from the defense?
I have him under subpoena. I would just ask that he be, that he's subject to recall. I spoke to Lieutenant Leadall. He explained to me his schedule.
Okay.
The Honorable Court will allow,
Okay.
if we have an opportunity to call. Lieutenant.
So what we're going to do from here is there's one more. They start the testimony of Brian Grove, who's an ATF fire protection engineer, and that goes into the following day. So we're going to cover that one tomorrow. And I'm going to stop off here because I have to jump off here in like 5 minutes. But I went ahead and redirected our stream over to Defense Diaries for the Kelsey Fitzsimmons filing. So if you go over there, tell Bob and Allie that I said hello and that Rebecca says hello, and tell them that you're here from this stream if you don't mind. This is enraging. I know it's going to get worse. These are just like these are just the evidence gatherers. They don't have any, they're not doing anything wrong in this situation. Seems to me like there's something going on with the GBI. But I'm sure it's going to become even crazier when we start getting into the more personal witnesses. And the one thing I will say is, well, a few things I'm going to say. There's some housekeeping stuff too. I would really appreciate it if any of you all who have been, following this case for a while, have already watched the trial, have been involved in the advocacy for a request. If you would email me, I put the email address in the chat. It's SomethingsOffPod@gmail. If you would email me and tell me pretty much anything any kind of tips you have or anything like that about the podcast that came out in 2020 and your thoughts on it. I find it very interesting that I've been covering this case for 2 days, and I just got an email from the creator of the podcast saying that he was touching base on behalf of Tara's mother. I found that really interesting. And so, yeah, he wants to talk to me. I'm not sure if I'm open to that yet because I don't need to be told what rumors there are or told what the facts are when I'm watching the trial. I think the trial is what Edric has been convicted on. And so that's my main focus. But let me know what your thoughts and opinions are. I would really appreciate that. Everybody go, if you want to. I know some of you have been here for the full 4 hours. But if you have the time and the energy, go and watch Defense Diaries. Bob and Allie are amazing. We're going to have them on the show pretty soon. Please tell them I said hi again. And then tomorrow, it's going to be a full day. I will probably in a few hours figure out what the time is going to be for tomorrow's stream for the Faust Trial. But we also are doing, we're having Aiden Carney on tomorrow night at 7 p.m. on our regular Something's Off stream. That'll be with me and Rebecca. So there's going to be a lot going on tomorrow. Just sort of be on the lookout. I will post as soon as I know timing of when the stream is going to happen tomorrow. But please let me know your thoughts. Let me know your opinions. Please go and like the video, hype our videos if you don't mind. Share, comment, subscribe, send us a tip, or become a member. Mainly, like that's what's sort of keeping us going. That's how I was able to set up the studio and pay the bills. So, we put in a lot of work to do this show. I don't want to beg anyone for money, but if you feel so inclined, please send over a tip through Venmo or Cash App, become a member. And if you can't do anything like that, I completely understand, but please do all the free stuff you can, which is liking and subscribing and hyping and all that shit. I love you all very much. Thanks for spending the afternoon with me, and I hope that you will go over and say hi to Bob and Allie and tell them where you came from and tell them I said hi. So see you all tomorrow. Bring your friends. All right. Have a good night, everybody. Bye. Happy hump day.